Okay. It's about to go down in a few minutes. Man, we got a lot to get into. We got a lot to tap into. We talking about accounting, securitizations, understandings. We got a lot to get into. So while I give people more time to get in, we are about 10, 15 minutes away. We just going to rock out a little bit. We're going to rock out for a little bit, and we're going to keep it pushing, man. We're going to get started in about 5-10 minutes until official start time. We're going to rock out for a second, man, to give everybody a chance to get in here, because if you're talking accounting, if you're talking securitization, we've been checking the airways. We keep our ears glued to the streets. We've seen it. We've seen people. We're seeing it's being confusing. They thought it was going to be easy. All you got to do is just cite A and C. They think it's just so easy. Now they're like, yo, it's not this easy. As they saying, it has nothing to do with the obligation, the firewall of the contract. Only 1% ever breaks through from consumers. The sooner y'all understand what I'm saying and listen to what I'm saying and take my advice, because it's backed by professionals, because I broke through the firewall in a federal lawsuit. I broke through a firewall. I'm telling you from experience, I've already accomplished what less than 1% can ever do from a consumer base, from a pro se and accounting based claims. I've already done it. I just served them. Now about to file for a motion for a temporary restraining order, and they haven't even attempted to come collect the vehicle or repossess since August, since I hit them with the accounting. They haven't even attempted. I'm still doing it. I'm still filing it. And the toll is tolling. They got about 12 more days to respond, and I'm waiting for them. I'm telling you, the federal judge did not throw my accounting and securitization claims out, and we're going to explain why. Let's get it. Yeah. Let's get it. Hold on, we're going to get everybody. It's Friday night.
You're rocking with the best.
We are in the building. And let me hold on. Now, why would you expect them to have a court case on accounting? Why would you expect them to tell you? Why would you expect them to expose the truth? If that's so true, why do I have at least 50 cases? Why did I cite at least 40 cases in my federal complaint? Hell, how did I even get past the Rule 8A and 9B motions in the screening against credit acceptance? This got served December 11th. The court got to approve that before you could serve them. You got to go down there and pick it up. And I said, yeah, I'm coming to pick up the serve. She said, hold on. Let me check with the judge right quick. Down at the Alexandria United States District Court for the Eastern District of Virginia. She said, hold on, let me see if it's cool for you to serve. She said, yep, judge said you could serve him. And then in the order I got, Judge Leona Brinkema said the plaintiff's August, I ain't gonna say the date, complaint will be the operative complaint in this action. You know what that means? I filed it August, November. It was approved. 90 pages. Hell, these gurus can't even cite 2 fucking court cases in their lawsuits. A 90-page complaint that flows like water, that just drips like water, talking about accounting, talking about securitization, where less than 1% of pro se individuals citing those never make it past the initial stage. But now they're saying, it doesn't apply. It's the difference. The court system ain't applied universal. All you got to do is say, I'm going to say ASC. I'm going to say securitization. That's it. No. Everybody's not going to get treated the same because everybody doesn't structure or argue it the same. That's what I'm saying. The new culture empire, we are with the 1%.
You're rocking with the best.
Give everybody a few more minutes, man. Let's get it. Hey, it's Friday night, man. Let me show you something. I told you I ain't make a payment since July 1st. Think I'm capping? I ain't make a payment since July 1st. Y'all seen the YouTube jump? But let me tell you something. Since July 1st, right? And you know what happens with credit acceptance? You don't make a payment since July 1st. You know what happens? Y'all know what happens. I be seeing y'all in the emails. Y'all know what happens if you don't make a payment since July 1st. Y'all know what's going to happen. Y'all know what's going to happen. Let me show you. This is what I'm trying to tell you. Everybody's not the same. So everybody's not the same. So let me just hold on. Let me show you. I gotta come out here in the cold. We out here in the cold. Let me show you. Oh, it's cold. Let me show you. Amen. Damn. It's too dark. Damn. Still too dark. Ain't make a payment since July 1st. You see that? You see that, Kenyatta? You see that? You see them? You see that, Kenyatta? Look. You see it? You see it? You see it? Look. Credit acceptance. I ain't pay out since July 1st. Credit acceptance. Look. Keep it parked right here. Black Mercedes Benz. Can't put it in the driveway because that's being occupied by the white Mercedes Benz. Come on, man. I am your teacher's teacher. Always remember that. Before I got to the federal civil side, I went to the box with the federal government on the criminal side. And it was my pro se supplemental brief that got my case held in abeyance for 5 years. And you know the criminal is way, you don't even have people offering services dealing with federal criminal cases. These gurus, they won't even take the case. I filed my own supplemental brief and got my case put on abeyance for 5 years. It took them 5 years to figure out a way to, it took them to 2 weeks, so I was about to go home, to figure out a way to deny me because they knew if they would have granted me relief, they have to grant 90,000 other inmates release. Boy, trailblazers, man.
Oh, it's too many people.
They talking about the accounting, ASC, securitization. Now we gonna see if you know what you know. Sheesh. Snapping. It ain't even about, because they live a different type of life. But when you come from the gutter, when you come from nothing, when you come from sleeping on your mom's couch to fucking monetizing your brain, having multi-million-dollar corporations silent because of what you took the years and time and spent and put that on your brain and got multi-billion-dollar corporations running from you.
You're rocking with the best.
And I'm just a regular average person to them, a regular consumer. I'm just a regular consumer, and I got multi-million, billion-dollar companies running from me. I was just in court, the lawyer for a multi-billion-dollar company tried to stop the judgment because I got the court dates mixed up and I didn't go to court in time. So I know the court rules. I immediately filed a notice of appeal to preserve my rights, then went in court and argued it, and she tried to get some he filed it 38 days late, and I said, Your Honor, I actually preserved my appeals. I preserved my rights for right now when I sent you the notice of the appeal. And the judge says, yes, he's right, he did do that, and I got the video of it. Let's get it. He snapped on that. Let's get to it. Let's get to it.
You're rocking with the best.
I need everybody to grab them.
You're rocking with the best.
I need everybody to grab them a drink. What the hell I just do? Oh shit. It's holiday special. I don't want it like that. I guess. And we are about to get into it. What has been going on in these social media streets talking accounting? Oh, what a very interesting topic. They want to talk accounting now. Now, let's ask ourselves a question. Do you think they've at least put in 3 years of intense studying of advanced accounting, all the nuances, all the court implications regarding it? Picking your brain, reading 70, 80, 120 pages of complaints and securities law, class action lawsuits dealing with the accounting, because the real accounting is hidden inside of these 100-page complaints, 225-page complaint. And I remember a lot of information that I started to uncover was on the heels of reading a 225-page complaint, and buried in like page 75 was talking about the same accounting standards that I teach in my group. Needless to say, that the class action lawsuit, they had to settle out with them. So you know me, when I see the top professionals doing their thing, I'm a sponge. I'm a soak it up. Okay, what angle they come from, what they doing, how they do this, how they do that. Bam. But here's the thing. I said, okay, I'm going to take their baseline, I'm going to study, I'm going to research, and I'm going to apply it to a consumer transaction. And this is the part where nobody online today can do.
You're rocking with the best.
And that's take a consumer financial transaction, accounting, securitizations, and do what? Apply it to a consumer transaction. Let me just give you a word of advice. If you plan on bringing up the accounting, that immediately turns your administrative claim into a court legal claim. It immediately turns your administrative claim into a court legal claim. You can't get around it by just citing the accounting and securitization. Think you're going to send a letter to the finance company and they just going to pause collection. It happened with you, but everybody's different. They don't treat everybody the same. And you're going to see this tonight. You are going to see this tonight with the videos and the case law that I have pulled up from the archives, talking about accounting, securitization, and why every person that lost on the accounting and securitization angle cited the same things in their legal lawsuits as the person that lost. So there is most likely no case law governing accounting. Did I not just say I mentioned at least 40 of them. At least 40 of them in my court case. And here's the thing. They think that there's a case law saying if you violate ASC, you're going to be held liable. Number one, the accounting is only for financial reporting. It has nothing to do with consumer rights. It has nothing to do with consumer rights. It's all about the entities, the finance companies reporting. There is no type of accounting standard that you can use as a defense to get out your obligation. When you cite the accounting, and this is the difference between me and the professionals on my team and everybody else, because everybody else doesn't know this. The accounting is only used to paint the narrative and the picture that you've already painted with your understanding of the transaction. Now, don't leave now. You're going to learn something good. It may be everything that you don't want to hear, but don't leave now. You're going to learn something good. So, as an introduction into tonight's stream, there is most likely no case law governing accounting. Once again, this basically means she's inexperienced and she has no understanding on accounting and how it works in court. That's a lie because I cited 40 in my complaint against credit acceptance. 40 at least. Most times you won't really specifically see it when researching any cases that solely go into accounting defense or exposure of the accounting, because let's be honest, no, because accounting is not used as a defense in consumer law. And this is the problem. They think that accounting ties into consumer law. They're never going to tie the two together. You have to tie them two on your own, and the courts have to accept that argument. It's not a guarantee.
You're rocking with the best.
So when you're looking at accounting, you're looking like the accounting has any relation to you, like it's a part of your consumer transaction. Remember when I told you there's at least 4 different transactions going on at the same time? Remember when I've been saying that? And no, it's not. No, it's not. And the only reason why they say no, it's not, because in their mind it's like, damn, I thought I knew it. Now there's more shit I got to know. And I want to move now. There's about 15 different players in any given securitization. And there at least, I'm going to break it down as much as I can so it's not too confusing. At least 4 different transactions going on at the same time. If you don't understand all 4 transactions, you'll never understand how it applies to you. And yes, I will say some of the stuff, you just got to know people that's been on the inside. Now that's some things you're just never going to find online. So let's be honest, they don't want people knowing the accounting, let alone challenging it. But if they didn't want people to know the accounting, how did you discover it? You see what I'm saying? So basically what Kiana Stone is saying is, I don't understand case law. I don't have the ability to research case law. Because let me tell you this. In my motion for temporary restraining order or injunction, even though they've already pretty much did that themselves, right? And in my motion for temporary restraining order in injunctive relief, although they've already paused on it, if you look here, as a matter of fact, let me show you here. Let me show you this. So she says there's most likely no case law. If anybody's in the Supreme Elite team, they would know that that is absolutely not true. Because for one, if you look here, hold on, let me turn my mic down over here. If you look here, this is my lawsuit. Look, this is my lawsuit. This is my lawsuit I put together. You see, I just keep scrolling and scrolling. How much you think case laws regarding accounting's in there? At least if I really do the count, it may be like 70. Wanna know why? Because they don't know where to look. Where they think they looking, it's not where it's going to be because they don't have the understanding. Look, still scrolling. Look, this is my lawsuit. This is what the federal courts read. Look, you just keep scrolling. Look, keep scrolling. Yeah. Do you think these gurus know how to put some shit like this together? Look, still going. Still going. Look, still going. Do you think they can put that together?
You're rocking with the best.
They will never be able to put nothing like that together. This is why I am so glad that they are talking accounting now, because all it does is make the Supreme Elite team stand out. I brought up the accounting in my client's case in Ohio. I brought up the accounting in my recent client's case. I brought up the accounting in my client's mortgage case because, once again, when I say that we're connected with top elite professionals in this field, people must thought I was lying, which all they did was confirm what I already knew. I told you, people are different. We're just different over here at the Supreme Elite team. We're just different. Attorneys are not accountants, but they represent the same finance company that the accountants work for. So how would they truly know who is obligated and how the accounting reveals the truth? They do know. They do know. The problem is you don't know. That's the problem, Kiana. You don't know. And this post is evidence you don't know. You think accounting is that easy? You could do a little buzzwords. Yo, unless you've been studying this nonstop for damn near 5 years straight on the advanced side, you are years away. I see what you're missing. The fact that you don't realize what you're missing, and I already see what you're missing, like I already know what you don't know, and I can easily point you in the right direction. I can easily point you to put in one input in the search engine, and you're going to start to bring up like 25, 30 cases based on that one case. And that's what I mean. There's a difference. Regardless if you like me or not, the reality is, it is what it is. But just know the FASB, ASC, GAAP, accounting, with governance accounting. Don't forget to study GAS. That's what I'm saying. Don't forget to study what? What are they studying it for? What is knowing GAAP or the accounting? What does that do for your contractual obligation when they come into court and say you didn't pay, you signed to pay, you didn't pay, you said we could take your vehicle? Do you think in a court law, in a courtroom, that you're going to be like, hey, I see this, this says this? Yo, they're going to steamroll right over top of you. If you say, oh, they've already been sued before, illegal interest rates, they're going to steamroll right over top of you. Want to know why? Because when you're the defendant, which 99% of y'all are going to be, none of y'all going to take the initiative to be the plaintiff. Y'all going to administrate their ass to death till they take your shit, then you want to file lawsuits. No. When you are the defendant, your arguments are way different than you're a plaintiff. When you are the plaintiff, then you can bring accounting in if you understand accounting. You can't bring up accounting as a defendant. I mean, you could bring it up, but it's going to be a hard matter because the court's going to be like, well, if this is so, why did you wait to get sued to bring it up? Why didn't you just bring it up? But you can't. I didn't know. I was just studying and I became aware. That doesn't work. See, I operate from the big boy, big girl school of court. Y'all operate from the, oh, it should be this way. Court should be this. They should, I hope. No. This is why my attitude is the way it is. This is why I'm right direct what it is. Because when you go to court, you're not going to get the grace that you're expecting to see. What supported case law do you have to support this? Go fucking read a book. See? Now it shows Kenyatta Stone catches an attitude every time she is challenged. And my last video, the exposed one, and shout out to Facebook for help running the numbers up. Over 800 views just from Facebook alone. Shout out to Facebook. The problem with that is it goes to show that Kenyatta Stone is going to catch an attitude with you when you ask her a question that she doesn't know the answer to. And then this comment right here, this post is nothing more than to gaslight and shield that she doesn't know accounting. Because the question remains is, Kenyatta, the new coach of Empire says he has at least at minimum, it could be way more. 50 cases on deck that's dealing with this. And he said he filed, and we seen him roll off his 90-page complaint. He said, shit, at least 40, he cited accounting on this. So he says he knows it and has it, but you said there's none, doesn't exist. Does that mean he's lying because you don't know those cases exist? Because that's how they spin it. Is he lying because you don't know it? Like, people just got to admit some things, there are things that other people know that you don't know. But the issue is not that. The issue is they're putting all this pressure on themselves by coming off as a teacher rather than recognizing that they still have understanding and years of study and research to go through. Once again, damn, I got to do more digging. Haven't found anything. Because you're not going to find it. Because you don't have the understanding where to find it. The new coach of Empire and the Supreme Elite team, we talk about case law like that's the normal thing. So what y'all still digging for, we cover normally every night. Like, that's nothing new.
You're rocking with the best.
Now look at this. Now look at this. What do they say? Name a single court case, please. I would love to look up the docket. Once again, it's not going to be in the places where you think. And even if you did find a court case, you're not even going to understand the language of it because you think everything has to revolve around your consumer debt. Like, you can't see it from no lens of you being a consumer. That's the only lens you'll be able to see it from. You can't see it from no other lens but you being a consumer trying to get out of a debt.
Please leave your message.
And Dan, I'm waiting for court cases as well. He's trolling because Dan already knows. Dan was just trolling him. What's up, y'all? Hey, hold on. These are new court. Some people remember in here. As soon as I read most likely knows case law governing accounting, I knew she cooked herself. Sounds good to someone who doesn't know. With the set nose, though. All right. Dan was trolling on that comment. He in the group. Y'all, we go over these case laws governing accounting every night. So for her to say that there's none that doesn't exist, she pretty much cooked herself. Now it shows the separation between me and people like her. And I swear to God, this has really nothing to do with Kenyatta Stone, because if this was checkmate, man, this shit would have been over with. I know she doesn't know nowhere clue as much as what I know. I know all her fans and her group members, followers, I guarantee with me, they're going to see the difference and they're going to get way more relief with me than they'll ever think about getting with her. I know this. This is not nothing new. I know this. This is what I'm trying to use also. I don't know everything, but I want to use it. There you go. See, that's the problem. They want to understand, learn accounting just to go use it for something. See, with the Supreme Elite team, we don't just embark on something. We understand it first. After we have understanding, then we go and execute. It goes. This is why 99% of people in these spaces will never get a remedy, is because their mindset. They don't even have the mindset for this. The mindset is nowhere where it needs to be. What are all the elements? There you go. Once again, that's a question asked for, and you didn't even get a reply. Do you think Kenyatta Stones knows all the elements? Do you know that when you deal with accounting, they all cross-reference each other? So you got to take a piece from here and put it from here and take a piece from there, 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 take a piece from there. And then another thing, most people don't even understand accounting language. Accounting language is very complex. A lot of y'all looking for my auto debt, my mortgage loan. If you do this, then the borrower doesn't have to pay. A lot of y'all looking for that language. You'll never see it. As a matter of fact, when you look at the accounting, there's nothing that applies to a consumer. There's nothing in the accounting that applies to a consumer. There's nothing in the accounting that applies directly to a consumer obligation. You have to make it apply. And these are case-by-case arguments. And you got to have case law to back it up. So with no case law, according to Kiana Stone, your accounting argument is flat on its face. It doesn't mean nothing. Securitization means nothing. It's flat on its face. I have court coming up soon. I'm trying to figure this out. Kenneth O'Brien, you will never figure it out in time for court because it's going to take you at least 5 years to fully understand accounting. See, the difference between me, when I popped up on the scene, I've already had years dedicated to this. These teachers, they just pop up out of nowhere and start studying and doing the things that they've done. This is how you could tell no one really got a real foundation, because everything these teachers done, it's already been done 20, 30 years ago. You can never find anyone in these spaces that ever put a complaint together the way I put it together. In the history of these spaces, I'm the first one ever. Actually, I'm the first consumer ever. I'm the first consumer ever to put a complaint the way I put mine together, ever. To the point where the watchdogs are watching my case. The consumer, the investors, the other law firms, they're watching how my case plays out. Because thanks to me, and y'all can thank me later, if this goes to trial and I win, all y'all are going to be the direct beneficiary of it, because it's going to force them to change how auto financing is done. It's going to force them to change it how it's done with you. So you should be rooting for me to win. Yeah, to me, it got just a little complicated. I was under the impression that the profits and proceeds for securitization were supposed to be applied to the principal balance. That's the wrong assumption. They never do. That is the wrong thing. And this is what I'm thinking. It's a consumer-like mindset. They don't know how to think of any other position but a consumer. Want to know why? Because they never study any of these alternative positions. They can't look at it from a corporate finance. They can't look at it from an investor standpoint. They can't look. A prime example. Okay, so let me tell you this. By me understanding all angles of securitization, I understood the angles from a corporate financing. So I know what goes into financing and how they do their financing, how they structure financing, how they file their tax returns on it. Then from the investor side, I study what it means to be an investor. If I was to do it, how it's represented on the tax return, how they do it, how they structure it, who's representing them, how their yield goes, and then consumer side. So once I knew all those other players, all those other 3 transactions going on at the same time, once I fully understood all those, then I was like, this is the part that nobody will ever get. Applying this to the consumer side. So you can see these comments, damn, I thought I was going to do this. It's not this. I can't find it. But I'm telling you, my court case, I did it. So it shows, okay, there's a difference here. But here's the thing, and I'm going to be very honest with you. The system is not designed for everybody to win. It's just not designed. You can be this is why I don't hold classes on Facebook. This is why I don't hold classes on TikTok. Because anybody, let me give you a word of advice. Anybody that's on a broad platform like Facebook, Instagram, TikTok, teaching this stuff, 9 times out of 10, they're just trying to make money off it. Because all the professionals know, and everybody who really understands knows, you cannot be publicly teaching this stuff. It has to be in controlled, private environments. This is why I teach this stuff privately. And this is why when I do post videos of what I've been teaching, it's muted, It's redacted. I block out certain words. It's not to gatekeep, but it's to protect me and my people's lane. We have a straight lane to our remedy. If I was to come and have a class live showing y'all everything that y'all gurus don't know, everybody's gonna jump. It gets convoluted. So I have a duty to make sure that the 1% still stays protected, because my group is a part of the 1%, because their arguments are going to be structured just like mine. My clients are part of the 1%. I can't have everybody making the same claims we make. They're going to shut it down. So ours are very unique, specific claims. And this is why everybody else, they're getting court judgments and summary judgments. But this is why you've yet to see any of my clients get a summary judgment off the break. It stops them right in their tracks. So that means, oh, I know something, that very small back door that the judges recognize, that is only limited. It's a limited door. I can't open the door for you to run through, because even if I was, it's still not going to guarantee that you get a win. It's a numbers game. When they see claims like mine, that's one in like every 1 million. But if they see 50,000 claims like mine, they're going to pass laws and they're going to stop any arguments, anything from it. So the fact that less than 1% of the population knows this, it's actually good for our bottom line. I mean, come on. When you become a millionaire, you'll be thinking the same way. You can't have everybody else being a millionaire with you. It devalues your money. Nobody's going to want to work. So this is part of the unfairness of the game, but this is something that's totally within your control. See, you can control you being on the 1% side. Oh, that's 100% within your control. I mean, everybody is not going to do it my route, study and get it out the mud on a professional level. Some people are going to need help and assistance along the way, which is perfect. Everybody's going to need that. But y'all following these online Facebook groups, these TikTok, YouTube groups, I mean, not YouTube, Instagram groups, Discord, or whatever. The problem is that only 10% of attorneys know this. Only 10% of attorneys know this. So if only 10% of attorneys know this, but these same 10% of attorneys knows court rules, they've been in litigation, they got about 10, 15 years of practicing, and then you go to a consumer that doesn't know court rules, that doesn't know court procedures, and y'all just come in and start spewing these accounting claims, of course you're going to be rejected. That's why the less than 1% of a pro se litigant ever wins on accounting-based claims. I'm telling you, when I say wins, I'm talking about getting past the first initial stage. The courts usually throw it out at the beginning. You made a fact, oh, I get everything right, and they throw it out because there's something missing that the courts know, but they're not going to tell you. And one of the biggest things, because everybody say everything is contract law. So unless the courts have a substantial reason to look beyond the contract, they're going to uphold the obligation. See, y'all want it both ways. Y'all want the contract law to apply when it's beneficial for you, but you want the contract law not to be applicable when you want to bring up accounting claims. They're going to enforce that contract against you. And you can, oh, ASC, oh, they did this, oh, Securitization. They're going to blow over it. No, you signed the contract. You shouldn't have signed it then. If you knew about the accounting, how it works, then you shouldn't have entered into the contract. That's all they're going to say. It takes very extraordinary cases for them to be like, okay, we're going to put your contract to the side and we're going to focus on what your argument is behind the scenes. It has merits. And then there's a structured way how that has to happen. See, basically what I'm trying to say is it took me years, over a decade, perfecting my craft. This is why I can speak with this confidence today and got the results to show. If you're just stepping out for the first time in court, you're going to get your ass handed to you. But that builds experience. You can learn from your losses and keep it pushing. But if you got situations where you need dire attention to, going to someone that's on a public platform, or I got this $220 packet for y'all, or I got this course to take, you're just wasting your money. Listen, I've been challenging these gurus to a live debate for 3 years. None of them has stepped up to the plate yet. I mean, you could send it to your gurus, your people. They're not going to challenge me. As a matter of fact, they get more out of the debate than me because they're not going to know nowhere near of the deep level. And I'm going to tell you why. Because even some of this stuff, you're only going to know unless you know somebody that worked on the other side. Like there's stuff that I know right now that I haven't even spoke on yet. Because I know that unless you are an insider and worked on the other side, that you're never going to know. That's just the game. And some of the stuff that you need to know, it's paramount to your, okay, so let me tell you this. Some of the stuff that I'm telling you that networking with people that worked on the other side that can whisper in your ear, that's going to stop them, a lot of them from collecting on you. That's going to stop majority of them from collecting on you. Same, and want to know why? Because I use the same thing in mine. And they just stop. In many cases, it's going to put a pause for cause on them. But you got to know somebody that knows, like even with your discovery. See, the discovery, I know it's going to end in the negotiations and a settlement. But a lot of y'all discoveries is just going to end in fucking summary judgment. So without further ado, y'all, I'm just giving you the reality. I'm giving you the reality. You ain't gotta like it. You ain't gotta I'm just giving you the reality of the situation. I'm giving you the reality of the situation. That's how it goes. That's how it goes. And this is why I have emails out the ass. I got emails out the wazoo with people trying to join my group because they know what I have is on a professional level. And if you think I'm lying, all you got to do is just ask your gurus, can they get their accounting claims through the front door? All you got to do is ask them, have you done it? You asked them earlier, can you provide court cases? You asked them earlier, can they provide court cases? And they wasn't able to do it. That lets you know right there. And if they say he's lying, there ain't no court cases, y'all know what that is at that point. So this is going to be one of the elements. Oh, because we're going to get into an actual court case when someone's citing accounting and securitization. Come on, it's Friday night. It's a long stream. Let's get it. Fair use. Fair use.
Distinguished Mr. Andrew Perry is here on behalf of Midland Credit. As I said, each one of these is a bit of a wrinkle.
Midland Credit. After this, I'm going to show you what my accounting document did to them. I scalps Midland Credit for breakfast. I'm going to show you Midland is suing Demetrius Custer, but I'm going to show you how Midland handled me. I told you it's on a case by case. The 1% gets the relief, the others don't. That's just what it is.
This is another motion to set aside a default. The default judgment entered in this case in the amount of $1,553.62 for Midland Credit against Mr. Cuscard. That was entered on November 25th. It was also set for a summary disposition hearing, and I granted summary disposition as well as the default. The defendant had no defense, and summary disposition was appropriate. The defendant filed a motion to set aside the default, but it was actually also a summary disposition. Mr. Perry, what's your position?
My position, Judge, is that Mr. Cuscard didn't properly file a request to set aside the summary judgment. And I think that's the real issue today.
It's always going to be the real issue. See, this is another thing that I'm trying to tell people. Number one, with the Supreme Elite team, we don't ever got to worry about summary judgment. That never happens. Once I step in, they stop. Uncle Rick. It's good, my G. Hey, y'all subscribe to Uncle Rick. Uncle Rick, put your YouTube in the chat. Y'all subscribe to Uncle Rick. Hey, Richard, Dax, Self-Made. Y'all will fuck with Uncle Rick. Uncle Rick like me. Well, I'm like Uncle Rick because I give him the respect because he's older. But straight shooters, we tell you just what it is, like straight out the. Yeah, I don't listen. I'm from the old school. My grandmother, grandfather, they tell you exactly how it is, and they don't care how you think. I'm straight up. I'm just straight the fuck up with it. That's just how I am. I'm just straight. I'm just a straight shooter. I probably got into more fights by me being a straight shooter growing up than I probably should have been in, but that's just what it is. And I'm almost 40 years old. There's no way I'm changing that. Now, when you're being sued and they file a motion for summary judgment, that is a total separate stage of the proceedings. You cannot respond to a summary judgment, which is denying. You have to put up substantial claims that states that there is a genuine issue at fact. They're only going to file a summary judgment or move forward. That's what it's called. Move for summary judgment is after you respond. You didn't state no legal basis or claims for your arguments or your defense. So that lets you know these social media teachers, a lot of their claims that they're telling y'all to file are BS. They have no legal basis. But when they file the motion for summary judgment, you cannot respond with a general denial. And that's what the young lady put in my chat. And I got sidetracked. I wanted to respond to it. You can't respond with it. Oh, I just deny. You got to set forth facts, evidence, documents, pleadings. You got to prove why there's a genuine issue here. And you can't litigate the same things that you got steamrolled over early in the proceeding because they're just going to be like, oh, I already ruled on that, denied it. So when there's a summary judgment filed, now your back is really up against the wall.
Today's hearing is whether Mr. Cuscard pled a request to set aside the summary judgment, which I don't believe he has.
That's a procedural error. Oh, for you accounting people, by the way, court is 98% about rules and procedure. Just like anything else in life, you got to know the rules and the procedure. Hell, life itself has rules and procedure, aka universal law. Life itself has rules and procedure. And court is 98% rules and procedure. The other two is the facts and the circumstances of your case.
Mr. Cuscard, one of my burdens as a judge every week is to explain to lay people what summary disposition means. You got sued in this lawsuit. The complaint was filed in March of 2024. You filed, it took a while for them to serve you, but you filed a very brief answer in June saying, I deny responsibility of owing this debt. Then you filed a little more expansive general denial where you denied everything. All right, that gets you past the default.
Right there. The general denial gets you past the initial stage. But here's the thing. When you file a general denial without stating concrete reasons, even when you file a general denial, if that's all you did, they're still going to move on to summary judgment. I had the same thing happen with my client out in Ohio. They filed a $17,000 debt against her. I moved for a motion to dismiss. The judge overruled that motion and ordered us to respond in 14 days. I respond in the motion and double down on the same arguments that I made in the motion to dismiss. Most people would have told me don't ever do. I said, nah, I know what I'm doing to set the trap. And then a few weeks later, it gets scheduled for civil pretrial. And then the phone call I released, they didn't even show up to court. They hired a rental lawyer. He didn't know shit. They completely didn't show up. Hired a lawyer. $100. Hey, I need you to step in for it. We don't want to come in for that heat. And now we're moving for summary judgment. Because one thing that I know, and one thing that the Supreme Elite team, we talk about, whatever you file at the beginning, you're stuck with it. So you better make sure you got all your ducks in a row, because I'm going to hold you accountable to your original motion, and they can never get around it. Man, when I say I am your teacher's teacher, you best believe they're watching in the clouds right now, taking notes.
You're rocking with the best.
Hey, gurus, y'all can come out the clouds and let you say, hey, come comment in the chat, y'all. Come on, social media teachers. Come on, man. Y'all can come up out the chat. Y'all come up out the clouds. I already know you watching. I already know. Now your video's starting to be more. Come on now, we get it. I start talking accounting. Now y'all want to talk accounting. When I stopped talking about the 1099A, y'all started disavowing. When I read the congressional records, when they saying that the government is not responsible for private debts, now y'all want to say the government's not responsible for private debts. God damn, I'm a trailblazer.
But it doesn't get you past a motion for summary disposition. A motion for summary disposition that they filed says there is no material issue of fact, and the
like what I said, you have to argue issues that are material in fact that prevents the judge from ruling in their favor. So when they file a complaint against you and you respond back, and then after your response, they remain silent, and then the judge schedules a civil pretrial, you have won that stage. You have cleared the pathway for you to issue your own summary judgment. You have cleared. That is a win for a consumer, getting past the initial stage and getting the civil pretrial set. Now, the court rules of procedure are going to get more intense because there's those in-between pleadings, those in-between motions, those in-between things that if you don't know that now is the time to raise it, and you figure out later and you try to raise it, they're going to be like, he had the opportunity to raise it at this stage, but he didn't raise it. And what's the response for a lot of consumers? I didn't know. And what does that mean? I don't know the court rules. I don't understand the rules and procedure. Court is about rules and procedure first. All that other stuff is secondary.
defendant has not stated any defense. They filed a history of the bill of sale disposition. A motion for summary disposition that they filed says there is no material issue of fact, and the defendant has not stated any defense. They filed a history of the bill of sale and a charge history.
That's exactly what they did to my client. They had the bill of sale. They had the contract. They had the amounts that they paid to the creditors. They had everything, and they still didn't get the judgment
Regarding this credit card. So we had a hearing. So two things. If you had shown up, I would have found probably summary disposition for the plaintiff, but you didn't show up for the hearing. So I found summary disposition was appropriate. Probably shouldn't check the default box. So a couple things. Why didn't you show up for the hearing? And in order to set the default aside, you have to set forth a material defense, meritorious defense.
That's what I said. A meritorious defense, meaning the defenses and claims that you raise as a defendant has merit. And remember, in civil cases, it's going to be viewed in the light most favorable to the plaintiff. So imagine they got the complaint. They filed a complaint. They got the contract. They got the bill of sale. They got all the dates. They got the amounts that they paid, and they still can't get a judgment. 99% of those people, that's all they get cooked right there. But once again, the Supreme Elite team is different.
So your meritorious defense says you were less than 18 years of age, which is not correct. You were born in 1971, so you weren't a minor when this contract was entered. The contract is void or voidable because we did not have a meetings of the mind, no wet signature. That's not valid. You had a history of charging things on the credit.
Hold on. What is the number one thing that people in their debt validation letters ask for today? What is the number one thing that people ask for today in their debt validation letters? What is the number one thing they ask for? The wet blue ink signature. Either people don't read or just don't have an understanding how the current financial system works. We are not in the 1800s. Everything is electronic. They don't need a blue wet. Why do you think none of that ever works? Let's be honest. When has a blue wet ink signature defense ever worked? Never does. Because they don't need to have it. And this is the difference when you're dealing with a teacher that understands the system instead of telling you everything that you want to hear or speaking in terms of what you believe. Yeah, y'all, because they got to have the wet blue ink signature. You know what I'm going to say? Hell no, y'all. Banning that claim because they don't need the wet blue ink signature because everything is electronically now. See, that gives you, you may not like it, it may go against what you believe, but at least you got a realistic understanding of the system. Instead of, yeah, y'all, wet blue ink signature, debt validation letter.
Card and paying the charges. They don't need those things. I should not have to pay this debt. Complaint is missing key elements, which is also incorrect. So there is no meritorious defense. And I don't know why you didn't show up for the hearing in November. So Mr. Cuscard, what's your position?
Well, my position is that I was having technical difficulties with the Zoom. You know, I'm not one of those savvy people when it comes to tech stuff.
Oh, we know. You ain't got to tell us twice.
And again, and like I said, you know, I couldn't connect with the Zoom. And as far as like the meetings of the mind thing, like I went through the packet that was sent to me that I eventually got, and I don't see my signature anywhere in there.
Never mind.
Well, you don't have to have your signature in there. You have a history of charging things on the card and then paying the charges.
Your Honor.
I was just about to say that. They don't have to. And no, and this is the difference between the Supreme Elite team and everybody else. Y'all look at, if it don't apply, let it fly. Y'all look at things based on what it should be, based on what you believe and how you see it, instead of looking at it for this is the system, this is how it operates, and this is what it is today. Y'all will still look at the system for what it should be instead of the system as for what it is. That's a difference.
Keep saying that you don't know that was me. I'm saying that I have been a victim.
They always prove my identity. Oh, Your Honor, you know I was a victim of identity theft before, even though I made about 5 payments on this account, but still.
So and again, and I do have a Capital One account, but it's not that account.
Well, they sent numerous monthly bills to your address that was in place in Kalamazoo.
And let's be honest, y'all. And the extreme cases of a identity theft, right? And when in the extreme case of identity theft, right? Let me ask yourself a question. Outside of those rare instances, normally in your lifetime and your experience, when you get a bill, you kind of know what the bill's for. You know that you got something on credit first. Now you got to pay the bill. Like, you know it. And this is one thing about the Supreme Elite team. I don't teach or advocate to be financially irresponsible or do shit just to get out of debt. I do advocate, honor that shit. And if you got a legal defense, we're going to put it together. I don't advocate doing this process just because you don't want to pay a bill. Now, if you can't afford to pay a bill, shit got fucked up, a family member got injured, lost a job, then that's different. But most people only are interested in this stuff just for the fact they don't have to pay a bill. And these are the people that never win.
At that time. All right. So there is a fundamental issue. You moved to set aside the default, but you didn't move to set aside the motion for summary disposition. So summary disposition would enter and did enter because there is no material issue of fact and you did not state any defense in your answer. You just stated a general denial. So summary disposition entered. In addition, you didn't show up. And then sometime after that, let me see when you filed the motion. The order entered November 25th, and you filed a motion to set it aside on December 9th. So it was within 21 days of the entry of the default. But I don't know what to say about technical difficulties. People have them all the time. People do have the right to just come into the court.
And Your Honor,
So let's assume technical difficulties is a legitimate reason. You still haven't stated a valid defense that you owe the debt. So,
and that is the number one point that all of a sudden accounting people are not taking into effect. Do you think that, prime example, if we take just what those people, what they thought the accounting was about, and they go on the court saying, hey, Your Honor, the securitization, it was supposed to be charged to the principal. Wrong. You're going to lose on that in court. Hey, Your Honor, the debt is discharged because the contract was securitized. Wrong. You're going to lose in that argument. Hey, Your Honor, the accounting, they didn't do this. They didn't pledge this. They didn't do this. And the number one question that they're going to throw back in your face is, did you sign this contract? Did you agree to pay on this contract? Did you make payments on this contract? Why should I not give them summary judgment right now or rule in their favor? We have the contract here. We have your agreement to pay. You've made payments. You haven't made payments. The contract states that they can repossess or foreclose if you don't make your payments. That, regardless of whatever accounting that you want to talk about or bring up, you still haven't accounted for that. And when you deal with these people, all that accounting stuff that you're talking about in court, it's not going to matter. You want to know why? Because the accounting doesn't release you from your obligation.
So excuse me, Judge Middleton. The very first court date,
it could potentially release me, but like I said, I'm not in the class as everybody else. The Supreme Elite team, we're not trying to figure it out like everybody else. We already know. And we got top elite professionals on our team. So we're not like everybody else trying to figure it out. We already know. So I'm speaking for been there, done that, and I'm telling you why you're not getting it done. I ain't trying to figure it out. They ain't no, oh yeah, we're trying to figure it. I already figured it out. I already got it. It's a difference. I'm talking about for everybody else that's in them Facebook groups. I'm telling you why you ain't getting nowhere yet.
I showed up to the court, right? And whatever it went, however it went, and you know, that day I was informed, hey, you didn't have to come all the way down. You could have done this by Zoom. So I tried that the second time, and it didn't work for me. And like I again, the whole wet signature thing, and not the plaintiff not presenting that I thought that was a relevant defense.
Wet ink signature. You want to know why? Because he went online and found this is when you go. This is when you deal with online teachers. So everybody, listen, y'all. Everybody that you see show up in these court cases and stuff. Look at this. These are people that are in these Facebook groups. These are people that are in these groups. These are the people that show up to court because they're in these groups on Facebook, TikTok, YouTube. These are these people. These are not separate people in the real world and they're separate people not in the group. These are the same people that are in the same groups that y'all are in right now.
Well, maybe in 1906, you had a wet signature. In the current era, things are all done electronically. And you pled in bad faith that you were 17 years old when this was entered.
No, I didn't say.
You pled in bad faith that you were 17.
Look, for all you wet ink signature people and your debt validation letters and your debt verification letters and your claims of defense, when you go to court, for every one of you wet ink signature people.
The plaintiff not presenting that I thought that was a relevant defense.
Well, maybe in 1906, you had a wet signature. In the current era, things are all done electronically.
You're rocking with the best. You're rocking with the best.
What did I say? What did I say? What did I say? So all you people in these Facebook, social media groups, when I say, yo, they don't need no wet ink center. Oh, yes, it does. Article of the Constitution says it does. I said, you're talking about 20 years ago. The normal days and the normal times. One way or another, y'all going to get sped up with the normal functioning days instead of keep thinking everything is fucking equity from 1854. Y'all going to start reading the 11th edition of Black's Law Dictionary, the 11th and 12th edition, instead of the 1854 edition, trying to cite words that they don't even use today, going into court citing Latin words, in propria propria, in propria persona, you sound crazy. But what am I getting? So carry on. The more people that's losing due to ignorance and willful ignorance and lack of understanding, that's the less people that we need to get in our lane. Carry on. You know what? I take that back. Go argue blue ink signature. Go do it. Go do it. Go do it. Please. I swear to God, please argue a blue wet ink signature. Please do it. Thank you. Woo, please do it. Y'all stay out our way.
And you pled in bad faith that you were 17 years old when this was
17.
entered.
No, I didn't say 17. I'm not 17.
Well, you said that you weren't a minor. You were a minor when you entered into this.
Oh, that must have been a mistake, man.
Right. And then secondly, there is no such thing as a wet signature. I'm not sure if you read that on the internet or somebody told you that.
Yeah.
That's not a thing. Summary disposition entered. You filed an answer that said, hey, I don't owe this debt.
Yeah,
and then you filed a more expansive answer that said, hey, I don't owe this debt.
All right, man.
That's not a defense.
Okay.
So for the reasons stated on the record, the motion is denied. And I guess it's my own fault. I just should have just checked the summary disposition box. Because this was summary disposition. Yes.
Even if Mr. Cuscard appeared at the pretrial and our motion for summary disposition, he failed to file a written response to our motion. And when we file a C10 motion, Judge, under G4, he's required to file a response and allege an issue of fact for trial, which he failed to do. So he didn't even do the first part and he didn't show up. So I would argue, Judge, that even if Mr. Cuscard appeared at the hearing that was set for motion for summary disposition, he didn't meet the requirements of G4 and raise an issue of fact for trial. So
that was
summary judgment would have been
earlier. You stated it more eloquently. Even if you had showed up, Mr. Cuscard, you would have lost. And you did lose because I entered a summary disposition motion. So you owe this debt. I don't have to like it, but your motion for summary disposition is denied.
Well, I got something to say. I have something to say, man. And all these predator collection companies, man, Your Honor, man, taking advantage of people who have no knowledge of the law. Now that's the real issue.
Well, I guess I don't have, I said to tell you I don't have to like it, but that is what the law is. I don't just pull out of a hat.
Buying things, pennies on a dollar.
Good luck.
Yep. Okay. Go.
Will you hand me my screen box? Chicago. Preach. Rah.
Credit acceptance versus Megan Pratt and Dylan Herman. The claim is for quite a bit of money, $12,762.27 plus cost, interest, and attorney's fees. A default
I hate when I do that. So basically, he said something about them not scamming the people, and then because you don't understand the rules. It's your job to understand the rules. Everybody wants things given to them because they have a consumer give me, beg entitlement mindset. Oh, you know it. You should just help the people. Help what people? Why do I want to help the people? To be praised? I don't care about being praised. I help me and mine and my clients. That's it. Want to know why? Because I understand the system. It's not designed for you to stand on a bullhorn and everybody to win. Because if they took away call consumer financing illegal, then that means unless you got the money on the wood, shit ain't gonna be good. That means you have to buy everything outright. So let's just stop. But when it comes down to when we take claims that are only designed heavily in securities laws, buried deep in the accounting, corporate financing, and tie it back to the consumer side, less than 1% can never do that. And the only percentage of that, less than 1%, 0.2, 0.3, is going to come out the Supreme Elite Team Group. Because these are the only people I see that's even going to bring claims of these magnitudes. Everybody else that's running around here, they're like 15 years behind the scenes. And I know them. I'm not going to say their names. You know, the obvious one, but there's more. Facebook don't have an understanding. I share shit with the professionals all the time and they just laugh at it. I share a lot of these gurus shit with the professionals all the time and they just laugh at it. And I was like, my point exactly. So when I say I know what I'm talking about, not just from my understanding, but I'm speaking the voice of the professionals that actually know the game. People that actually worked at the agencies that governs these transactions. Like, what are you talking about? You think I'm not going to know how it really works on the inside? Come on, man. Tripping. But the reality is most people are their own worst enemies in this. The only one, and as a matter of fact, hold on. Let's hold on. I ain't even going to sit here and gaslight you all night. I ain't even gonna gaslight you all night. I ain't even gonna gaslight you all night. I ain't even gonna gaslight you all night. New client. Hopefully they answer.
Thank you for calling.
They'll call back. They'll call back. Or if they do call back, I'm just gonna ask her, hey, straight up, what do you feel about my services so far? I guarantee it's gonna be a heavy praise. And this is an attorney. No, let's not get it twisted. This is an attorney that has background in securitization. So let's not get ahead of ourselves here. But we have credit acceptance coming up in this next video. We have credit acceptance coming up. I have a federal lawsuit dealing with credit acceptance right now. Everybody should know. Everybody should know right about now. Well, if you're new, everybody should know that I have a lawsuit dealing with credit acceptance. They have recently been served. So a lot of the accounting claims, a lot of the accounting claims that all these gurus are posting videos and making posts about, I'm not going to say I did the same accounting claims because I'm not, because they don't do accounting claims like I do. But I will tell you this. Credit acceptance have went into hiding. Let me just say that. And now, although they did everything that's indicative of a temporary restraining order or injunction, they haven't attempted to collect. I was just outside. Y'all see my truck is still there. I don't hide it. I leave it right there. I leave it right there. Right, park right out front. I don't hide it. And what I'm basically saying is there is this lawsuit, if no change, if they don't settle, can actually change the way consumer finances. I anticipate that they're going to settle for the simple fact that if they don't settle, that it's going to expose them to bigger problems. Now, here's the thing. This all took place before I even filed the lawsuit. So check my credit acceptance app, and after the past several days of I didn't take myself off payment auto pay. I didn't take myself off auto pay. Actually, I forgot about it, to be honest with you. I forgot about it. I'll be honest with you. I actually forgot. I probably would have if I remember. I actually forgot. Payment information was not available. Okay. And there's a reason why I'm doing this, because we got a credit acceptance case coming up in this video. Talking to them, basically trying to get them to settle with me. And they said they were open to, just. I told them, I said, yo, if you try to take this to trial, you're going to lose over the phone. I said, it's not just me. Y'all going to have every consumer advocacy company up against you. Y'all going to have every class action lawsuit coming at your throats. Y'all going to have, it's not just me. I'm just opening the gates. They're going to be hitting y'all with lawsuits left and right based on this case here. And they said, well, have your lawyer reach out to us. We don't settle directly with consumers. have your attorney contact us and we'll start the settlement process. And that's what they said over the phone. Yo, have your attorney contact us and we can start the settlement process. But we're not going to settle directly with consumer. I said, I'm representing myself. So you're going to have to look at me as an attorney. You have to get up out your status and not settle with consumers. But there's going to be no attorney assisting me on this one. So what I'm saying is it's in your best interest to settle, because it's only going to get worse as it proceeds to the stages. I haven't even let y'all know everything that I have on you. And it was already scud missiles in that email. But that's only 4% of what I have on you. Like, I didn't tell them I have y'all internal documents. I have y'all internal documents, shit that y'all don't even make public. Like, and I don't even attach that to my lawsuit. Hell no. You don't do that. You don't do that. I didn't even do that. I say, I'm not even going to do that to y'all because I can get y'all right off my merits. But release me from the lien and taking the vehicle. But no, I have some equity built in on the other side of the contract, which you will find out in the webinar if you join. So I called 2 days ago. They was like, yo, have your lawyer reach out to us and we can get the settlement process started. But CAC is not going to be negotiating directly with you. So I said, oh, you won't you? Well, since I'm pro se, the attorney, you're actually, you're going to have to talk to me. The federal courts is not. 100% scalpel. Oh, what do you know? What do you see right there? ASC. What do you know? What do you know? See, there's my version of the accounting standards and Facebook's version. Oh, two totally different things. Now, do you think if I was off, the judge would have allowed me to serve credit acceptance? The courts would have threw it out. It's frivolous. Just like they're going to throw everybody else's claims out that's just jumping on this new wave. Let me tell you, all y'all shit about to get thrown out. Because to really understand this stuff, it takes years. And it takes mentoring and counsel from the professional. Y'all just trying to do this based on what somebody else online told you. You don't even know if you have the right interpretation of what you're reading or not. I mean, isn't that a common theme? Y'all misinterpreting everything you read, taking it literally. How you know you got the right interpretation? How you know? How do you know besides leaning on you? And obviously, I don't have a history of interpreting everything correctly. I mean, to be honest with you, y'all be using a statute from Title 18, crimes and punishments, definitions of obligations or other securities under Title 18, crimes and punishment, and try to apply that definition to your fictitious negotiable instruments. Basically, you're sealing your own indictment by even using Title 18 USC Section 1, Title 18 USC Section 8. Definition of obligations to other securities in the United States. See how literal y'all take that? It only applies in criminal cases. See, that right there. You can't even trust your own interpretation because 99% of your interpretations are off. You have no clue what you're talking about. But this right here, this is a lawsuit that you can believe in. To talk to me. The federal courts is not going to make me get a lawyer when I have the right to. It's unavailable all of a sudden. Damn. Come pro se. So I checked today and this. Now, normally you log into the app, you can see We don't even need to say nothing on that one. Let's go ahead and just drop it. Let's just drop it. Let's drop it.
You're rocking with the best.
An accounting document. This is an accounting document. So you social media gurus, the bar has been risen. You got to get at least this. Hey, if you online talking accounting, you got to at least come back with this. But it's been like that since what, August 18th. Everything is right on demand. But now, now normally you log into the app, you can see everything is right on demand. But now, and I tried about 3 or 4 times, that nothing. And the lawsuit is actually not even filed yet because I tried to do it Friday online, but United States 225 pages. 16 months of investigation. I investigated them for 16 months before I pulled the trigger and filed the lawsuit. You can just imagine what I know. You can just imagine. But if you look at these social media gurus, they don't even cite one court case in their lawsuits. And 50 of these cases is all accounting cases. So when Kenyatta says there's not one, well, it's all up in there. Y'all gonna learn in 2026. District Court for the 4th Circuit, they don't allow you to do it online, so you either gotta mail it or go in the office. So you either gotta mail it, but United States District Court for not even filed yet because I tried to do it Friday online. But United States District Court for the 4th Circuit, they don't allow you to do it online. So you either got to mail it or go in the office by itself, and file the paperwork, the lawsuit. So I am still filing the lawsuit Monday. And if we reach a stipulation, then we'll do a proposed stipulation to dismiss the suit if my reasonable demands are met. But that's what set it off right there. That's what set it off right there. I sent them an email. Y'all 5,000 documents y'all can put together. I sent them an email. An email. Different. It just goes to show, because I sent them a very detailed email and attachments of every single thing that I was going to raise in the lawsuit. I didn't hide nothing. And I sent them what I was going to request in the discovery.
You're rocking with the best.
It sent them 29 pages of the lawsuit. Also, I sent them a copy of what I will be reporting to the IRS on. Now, we have not officially reached a settlement yet. At least I'm unaware of it. But I know how credit acceptance operates. They are not about to make this an NA or you can't do this now or none of that. They are one of the most notorious finance companies for repossession if you miss 2 payments. They are notorious. They'll repossess at 2 a.m. They'll repossess at 3 a.m. They'll repossess later at night, and they come in and snatch. Well, it started this live stream. My truck, I could actually look through the bottom of the blind. Still out there. I don't even hide it. I don't even care. I don't even hide it. Because I know they're not coming. I know they're not coming. See, that's the difference between the Supreme Elite team. So you got the Supreme Elite team, New Culture Empire, then there's everybody else. Nobody can fit. We're in a lane of our own. That when there is something wrong with their ability to collect, or there's something going on as a legal matter. Any other time, you can log into the app. You can see when your payments made, the last payments made. I told them as of July 1st, all the payments will be making to the court. So I have July's and August payments that I will be depositing into the court. And I sent them an email and the screenshots of the money orders I took out for the payments. And I said, hey, if you want these, you're going to have to meet me in court to get them. So I have the money to pay. It ain't about. Man, I made 37 racks that month. And I made 37 racks that month. A credit acceptance, multi-billion-dollar company. Come on. I'm calling you on. Pro se consumer. Come on. I'm no lawyer. Because everybody that they settle with, consumers, they had a lawyer. Nah, I don't need no lawyer. I'm going to do this all myself. Every stage of the case. Come on. Credit acceptance. Come on. Come on. Calling you out. You want your money? You know where to meet me. Oh, not being able to pay and they want to use this to get out of it. Damn, I made damn near $40,000 last month. It's not a big deal. Could pay the whole thing off right now if I wanted to. But no, it's about asserting my rights, still paying on the contract for over a year while I was gathering the information so I can present my claims in peace instead of trying to do it because my back against the wall and they're trying to take my stuff. No, we make sure we have sufficient funds to cover the obligations until it's time to take it to the legal proceedings. And this is the part that separates us from everybody else. Most people will never take that route. They do this shit because they can't afford to pay. We do this shit because you're not about to play in our face. There is a difference. And then all the payments that I will make to them, we're going to get money orders and we're going to deposit those payments within the court. See, that's the right way of doing things. See, I know that is not a popular way with most people because most people only do this when they can no longer afford the bill or don't want to honor their obligations and then wonder why their outcomes are the way they are because their spirits and their energies and their inner intent are devilish. They're not coming in good faith. They're not coming with righteous intentions. They don't have real legal valid claims. Only, hey, I can't afford to pay anymore, don't want to pay anymore, and I want to use a loophole. No, we're going to pay until it's time to bring the legal suit, and then we're going to take money orders out and pay the courts. So what I'm saying is everything that I talk about, everything, the paper trail, the lawsuit, and the lawsuit is not even officially filed yet. But they received the email and they know damn well what is. All right, let me stop time. Yeah, I see people getting mad. Let me get back to it. Y'all getting mad. Hey, y'all can come back now. I'll start showing receipts. Come on now. Come on, y'all can come back now. I'll start showing receipts. We're going to get back to normal programming. I'm going to stop showing receipts. Hey, well, one thing about these spaces, boy, they hate when you got receipts. One thing. Now, when you're just talking about it, hold on, let me put it at the box. I'm about to add this. Now, when you just talking about it, and you just talking and you're showing, they all in. But when you actually got receipts, they tend to leave. They don't want you to show receipts. And why don't they want you to show receipts? Want to know why? And I really don't give a fuck because half of these motherfuckers out there can afford me anyway. Like, half of these motherfuckers can afford me anyway. Oh, I know. Well, that's exactly what they think. It's going to be a $150 class. And you want to get this packet. And all you got to do is fill out your information and send it in. And the teacher is going to promise you everything in the world to promise you to get that money about you. And as soon as you come back with a rejection letter, they say, oh, blah, 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 do your research. Oh, donations. Oh, no refund. It's a donation. I told you it was just for educational purposes. Yada, yada, yada. But yeah. And during the 16 months, that's exactly what I did. I continued to make my payments timely. I said, nah, I'm not ready yet. I'm still going to honor it because I don't want to study. I don't want to study and just pay it. Just pay it. I got the benefit of the use of the truck. It's a very nice truck. It's a Mercedes-Benz truck. It's a very beautiful truck. Very good on the road. So I'm like, I'll pay. I'll pay now. I ain't no problem. But when it came time to pull in the plug, I told them. And my last act of good faith, I said, I'm gonna give y'all one more payment as an act of good faith, but you'll never receive a dime again from me. You gotta meet me in court. So even in the last, I still show the act of good faith.
People who have no knowledge of the law. Now
that's your fault. That's your fault. If you had no knowledge of the law, then you were supposed to pay your fucking bill to stay away from this. I know people that pay their bills because they don't want to deal with the courts or deal with having to get their shit taken. Pay your fucking bills. Y'all, if y'all saying this space is so confusing, everybody's saying this and they're saying that, and there's so much stress and I don't know who knows, then pay your fucking bills. Pay your fucking bills then. Y'all want to talk about all that, but you can alleviate all this by just paying your bills. Pay your bills then. If you don't want these teachers scamming you and they saying one thing and you doing this and it's not working and this, then pay your fucking bill. You don't have to worry about a social media teacher just telling you anything. Pay your bills. Exactly. Fucking, and this is the reason why y'all don't get remedy. Like, a lot of y'all will never get it because you're not even designed to get it. Y'all don't even have the mindset. Y'all don't even have the patience to allow yourself to understand. The only reason why half of you Facebook, social media people here now is because someone told you it's something you can have. And this is why y'all being exposed. In 2026, either you're going to understand or you're not. There ain't no packet that's going to save you. There ain't no template that's going to save you. Either you understand or you don't.
That's the real issue.
Well, I guess I don't have, I said, I tell you, I don't have to like it, but that is what the law is. I don't just pull out of a hat.
Buying things, pennies on a dollar.
Good luck.
Yeah, see, all that is frustration. Then why did you sign up for the BS? Why you put yourself in that situation for them to take you to court to do this? See what I'm saying? No accountability. And I'm going to say this, and people hate when I say it. Nobody forced you to fill out the application. You knew what was up. You knew what was up. Don't want to hear no meanings of the minds. It's fraudulent now. Because if it was fraudulent, why didn't you do what I did? Why didn't you raise issues the very next day? Why didn't you raise issues? And you want to know one of the reasons why the judge let me, I believe why the judge let me through? Want to know why? Because in part of my complaint was over the course of 16 months. Defendant has sent communications to them, this to them, explaining this, explaining that, However, defendant still made timely payments on a contract that he know he wasn't legally required to pay. That's called equity. Your Honor, they did this BS the whole time. I've been letting them know for 16 months, but yet I still paid. Y'all coming in just not paying, getting sued, and then when they bring up accounting as a defense, you're going to fucking lose. And I don't give a shit who don't like it.
Okay. Go.
Will you hand me my screen box? Now go.
Credit acceptance versus Megan Pratt and Dylan Herman.
Hold on.
Will you hand me my screen?
Versus Megan.
Hold on.
Now go.
Credit acceptance versus Megan Pratt.
Credit acceptance. Credit acceptance.
You're rocking with the best.
Credit acceptance. Hold on. Why y'all even in court with credit acceptance? Why y'all even in court with credit acceptance? The only way we go to court because I taking them to court. Why didn't they put a pause on your account? Why didn't they put a pause on your account? Shit. Credit acceptance is easy.
And Dylan Herman. The claim is for quite a bit of money, $12,762.27 plus.
So they took them to court over $12,000. My total amount of payments is $41,000. They ain't take me to court. And they ain't take me to court. On the contract, I owe way more than them. You know the difference between me and them? I know how to make that contract look like a piece of toilet tissue. I know how to make that contract look like a piece of toilet tissue. I break the See, most people gonna argue the contract. I take the contract and reconstruct it to say what's really going on. That contract means nothing to me in court. That's just me, though. That's just me. That's just the Supreme Elite team, though. Everybody else, not them. But that's just us.
Cost, interest, and attorney's fees. A default judgment entered in this matter in December. Have these all tabbed out. That was entered on December 9th. The defendant filed a motion to set aside that default on date stamped December 10th. So it was within 21 days. She said, I did not answer on time because I thought I had, I can't tell what that says. Looks like it says 811 business days, not.
Should say 21 business.
21 business days, not calendar days. I made an attempt to answer, but I was told there wasn't a specific paper. So I returned home to both my wife and I could write out our answers. So that is from Dylan Herman.
There's more than just that.
Then they filed a more extensive answer regarding the default. Plaintiff's response is the court rule that says two factors under the motion to set aside a default judgment. It was 2.603. They have to show good cause, D1. You have to show good cause or reasonable excuse for failing to respond to the lawsuit. And you have to provide a meritorious defense to the action required. Credit Acceptance Corporation lent you the money to buy a car, and they're the lender. And in your answer, you are raising issues regarding the car, and these are always bought as is. And then you also indicate that you are using SSI as your means of income, and you're right, they can't seize or garnish that. You also make some other veiled references that they took too many.
But hold on, Your Honor. Fuck. Damn it. Hold on, Your Honor. So you said something
That you are using SSI car as defense to the action required. Credit Acceptance Corporation lent you the money to buy a car.
That's not what I said in my lawsuit. It's not what I said. I said the actual opposite. Damn, Judge, y'all really be gatekeeping. Y'all think I gatekeep. They be gatekeeping. Damn. Judge, you know that ain't happened? Why you sit there and gaslight them people like that? Judge, you know that didn't happen? Damn.
And they're the lender. And in your answer, you are raising issues regarding the car, and these are always bought as is.
Damn. Judge, you really gonna do them like that? Shit.
And then you also indicate that you are using SSI as your means of income, and you're right, they can't seize or garnish that. You also make some other veiled references that they took too many months, which would be a violation of the statute of limitations, and I don't find that's the case.
Damn. Damn, Dylan and Megan, that shit still ain't hurt. See, Dylan and Megan, if you would have contacted the Supreme Elite team at thomaslegacy603@gmail.com, I guarantee you I would have had a better defense.
So, Ms. Notice Hartman, you're the plaintiff. Thank you for filing a responsive brief to their motion. You wish to speak to that further?
Judge, just to really drill home, they don't present any.
And not just credit acceptance. Bank of America, Wells Fargo, Santander, Westlake, Fannie Mae, Freddie Mac, JP Morgan Chase, all these United Wholesale Mortgage, United Postal Service, Nike, Reebok, oh, Walmart. Oh, yeah. All their underlining financial. Oh, yes. Medicaid, insurance, Progressive, Geico. So I say, I understand the system. Study them all. Midland, Synchrony. Your work ethic is going to show in your results. It's going to show in the documents you produce. And this is why it's me and everybody else is there. Because you could tell I put years into this. You could tell they just popped out of nowhere, started a few years ago, started teaching this. So when they first just got aligned to this, I was already here with it. Don't get mad at me. You could be jealous of my work ethic, but don't be mad at me.
Reasonable excuse. They both admit that they were served and that they just didn't know what to do or misunderstood, which the summons clearly tells them what they need to do. So ignorance is no excuse, especially when it was.
So they're going to steam right over top of it. The same way I chose to use my time and make sacrifices for this, because I see the big picture, what can happen. are the same reasons why 99% of these people are in these spaces to take shortcuts to get the results of someone who's been studying 10 years. But then themselves, they won't even take the initiative to do the same thing. So if you're really going to be mad at someone, you can only be mad at your own ignorance and your desperate mindset where you're just going to trust anybody because they're telling you what they want to hear. And this is why I call people the low-hanging fruit.
Explain to them on the summons. Further, technically the answers, I guess, that you could say that they filed shouldn't even be applicable because they weren't granted the opportunity to file an answer. But even stating that, as you stated, they don't present a meritorious defense to the claim.
Because they don't know how to argue a meritorious defense. Miscredit acceptance attorney.
So their claim and their motion is required to be denied under the court rules.
Why don't you speak?
Keyword. Court rules. What are the two things I say that people don't understand? The rules and procedure. There you go. They think court is about coming to court and just telling the judge what happened.
Speak to that further.
Sure. Which portion? Their defenses or their
Yes.
alleged defenses?
Yes.
So,
Yes.
as I stated, and as you alliterated, Judge, they first kind of contemplate issues with the dealership of the car, which again, this was financer, it's not the dealership, so they're not responsible for whatever issues they may have had with the dealership. A vehicle is purchased as is, so again, they don't have any liability as it comes to the vehicle itself. They basically gave them the money to buy the car, and that's where the liability comes in, that they just owe plaintiff the money.
See? I find that so many people that scream securitization can never help their clients get past that argument. Credit acceptance loaned them the money to buy them the car. Now, we know, I said I've been studying for 16 months. We know that's not true. But what's even crazy is the comment she just made. In my email, I told them, you didn't loan me any money to buy me a car. As a matter of fact, let me tell you what you actually did. And I proceeded to break down their whole internal model, which they didn't think I would have. And this is why you see credit sectors treat me like this, but they'll take everybody else to court.
So unfortunately, it fails there. A couple other things I noticed in their response was that they stated they just couldn't afford it. It's because they're on SSI, which again, unfortunately, is not a valid legal defense. They stated something about frustration of purpose in the 777 rule, which, you know, I can deny flat out that that's incorrect because I have their file up and there was no violation of any FDCPA issues. And again, the time to do that would have been when they responded to the complaint, which they failed to do. They admitted they failed to do, and there was no reasonable excuse under the court rules. So both it fails on the first prong, which in turn it fails on the second prong. So therefore they haven't met the burdens under the court rules.
All right, that's a expansion of what was in their brief. The lawsuit was filed on September 16th. It was served on each of you on November 3rd.
Now let's just pause.
You have
for a
21
second.
days from November.
Let's pause for a second. Do you notice how all the claims that these people down at the bottom are making? Bottom, my right, my left, your right. Notice that all those claims fell under the court rules because it doesn't matter about your claims unless you know how to bring your claims under the proper procedure and follow the exact rules for the claims you're trying to make. See, people think that the court rules and the procedure are independent of their claims when they're actually interconnected. You don't have your claims unless it's under the proper rules and you're following the procedure in which you bring those claims. See, this is the difference about understanding court, being in court. And this is all from experience with me. There are many things that you're going to pick up on court through experience. If you think you're just going to come out the fucking out of nowhere for some Facebook group online and think you're going to start winning in court, you have lost your mind. You can almost guarantee with court, you're always going to lose before you win. Damn, I know there's people, I got a court case coming up and I really don't want to lose. That's the reality. You always lose before you win in court.
November 3rd to file a answer. The summons says on its face in big black letters, you have been sued. You have 21 days to file a complaint. And then it goes on to file an answer. So they allege, A, that you didn't cite a good reason for not answering, and more importantly, nothing in your response sets out a defense to the fact that you owe this debt.
And what is everybody talking about online? Oh, this is accounting. I told you, the accounting means nothing when you're staring down the barrel of that contract. And if you try to use accounting to say that you don't owe or the debt is discharged, you've lost again. I know people don't want to hear it, but you rather me tell you the truth or lie?
So either of you wish to speak to that?
Yes, so Your Honor, it does say the 21 days. I have the summons here and the envelope that the gentleman gave me. And I did not know, like, on that day, like what day it was, I guess. I knew that day, obviously, what day it was, but later on, I'm like, okay, were we served on Monday, Tuesday, Wednesday? There's nothing here that says what day we were actually served. And then the courthouse themselves were closed for the holidays, for Thanksgiving and everything as well. And we did come in twice to respond to this because it also said,
you get a summons. You have 21 days to respond. What is the first thing that anyone is going to do? And what day is it? What's the date? I mean, 21 days from there. But if you read the court rules, they tell you if the date that you're supposed to respond falls on a holiday or weekend, it rolls over to that following business day. But if they would have read the court rules, they would have known that.
Under you have 21 days, it says you must file a written answer with the court and serve a copy on the other party or take other lawful action with the court. So it says if you do not answer, blah, blah, blah. So we came in and we asked.
To y'all defense, it doesn't even matter if you would have responded or not. You were still going to lose.
For that written answer form. And that's when we were made aware that, no, you can't use a form. Just go back and write it on paper. I'm like, okay. So then that took another day to come back and write it. Then we called and asked a question about it. And we spoke to a lady there. And then
see, when you're dealing with someone that understands the court rules, we don't do none of this. We already know what to do. We are not. This is look at all this extra days because they don't know the rules. But I bet you at not one time did they study the court rules. And here's the thing. Even if they did study the court rules, they're not going to understand it before court. Court is something that takes years to understand because there are nuances that are not going to be taught in the rule books. You're only going to understand by being in court in situations like this and gaining experience. You get better at court over time. Court is not something you just come out trailblazing and starts winning. Court is an acquired taste. You get good, like me. I got good at court over time. The motion I was filing in 2013 is nowhere near like the ones I filed today.
See, most people don't want to go through the growing pains of this, meaning you got to take your L's along the way. I've taken my L's along the way. You all, the SEC attorney, he took his L's along the way. You always lose before you start winning it. But since people need to win because they're trying to save that tangible property of theirs, they'll just start doing anything.
Holidays for Thanksgiving and stuff, and then we came in, or we called because we were coming in that first week of December, and that's when we found out that there was already a default judgment being signed, and so she told me to come in anyways and just file this new motion.
Well, it didn't actually get signed until December 9th, which was 30,
before my motion.
34 days after you were served. But more
34 days after she was served. It's a long time to respond.
importantly, you don't have a defense to the fact that you owe the debt. Your complaints are with the auto dealership.
Now, everybody that's talking accounting, all that accounting shit that you're about to go to court and cite, that's what the judge is going to say. And you know what they're going to say? Okay, I'm going to tell you what they're going to say. Okay, so you're bringing up the accounting, and Your Honor, that doesn't apply. They signed the contract. They signed up for the debt. They haven't paid the debt. But and as soon as y'all realize that, because a lot of people in you Facebook, TikTok, social media groups, you think that if you say a buzzword, they're going to back off. They're not backing off. They're just going to. What do you do then? What do you do then when they say the other, Your Honor, and then the judge says, "Well, I'm looking here at the contract. What does the accounting standards have to do with your contract? What does securitization have to do with your contract? This is a contract. This is a debt. They're suing you for a debt." You ain't gonna have nowhere to turn. And think about that. Wanna know why? Because all you social media people, you never look at the system from an objective standpoint. You never factor in, okay, what they gonna say? How can they go? But how do I counter this before they say it? Y'all think, okay, I know it, I say it, they back off, I win. Come on, y'all know what y'all thinking. Your ass in for a rude awakening.
And this is the finance company that lent you the money.
Right there.
Now you're
right. But with credit acceptance, I said, no, they didn't. As a matter of fact, of course, I'm not going to tell you here, but yeah. So you notice how the judge in one case, they'll say, oh, the finance company let you money. But in another case, Your Honor, the finance company never lent me no money. And it's accepted because the system is not fair. The system is not a one for all. Okay, so look at everybody that's in your social media gurus group, like a Facebook followers, right? And let's say they got about 50,000 followers, right? Out of that 50,000 follower, maybe one person will ever win. Yeah, that's like maybe one out of the whole 50,000. But isn't it like everybody's vying for the same victory? They're all doing the same shit. But you understand the system. You realize maybe one of you will ever get close to getting past the first stage. But they don't realize that yet because they thinking that, but they don't know it yet. That's the most scary part. And I really be scared for them because I'm like, damn, they don't even realize that they're never going to get through the door this way. I'd be scared for them. Like, damn, all 48,000 really think they about to get the same relief. Shit.
contending that they haven't really lost anything.
So the vehicle
not
was
sure.
returned. The vehicle was returned to them. It was attempted to be returned to them immediately at purchase multiple times. They refused to cancel out the loan or work with us on the loan. And then
I should have never shown receipts, y'all. They rolled out. As soon as I saw receipts, they rolled out. They said, and you know what they're really mad at? They're mad at their teachers but they project they're mad at their teachers on me because they're like, damn, my teacher ain't never showed that. Damn, Kenyana Stone never shown that. Damn, she's never shown that. Damn, he really sounds like he knows what he's talking about, but I don't like his attitude. Damn, like he literally showed that credit acceptance stopped collecting based off his accounting. Damn, I got credit acceptance. These motherfuckers ain't stopping. I done sent them a lot of shit and they done denied mine. What makes him think he better than someone else? What makes him feel like he's so fucking special? You know what? Let me leave.
Later on, the vehicle was not usable in any way, shape, or form within 30 days of me purchasing. There was electrical issues with the vehicle. There was multiple times that the radiator along with the alternator had to be replaced. It was not a safe vehicle at all, which obviously that goes back on whoever sold it, the company that sold it to us. But we had contacted the lender to cancel out that loan multiple times. And they told me just to keep paying on it. They put me on payment plans. They kept telling me like it'll all work out and call us if you need this. So then
and this is what I mean. You don't, you can't, I keep my foot on their fucking necks. You keep your foot on it. Like you, okay, when you get your finance company, you just get them, then you just take them by the neck, you just squeeze, and you squeeze, and you see their eyes bulging right on the brink of death, and then you release. Right? And then you squeeze again, you squeeze, and then you release. Right? And then you squeeze, then you release. That's what I'm doing with credit acceptance.
we took it into another place. And then finally, the vehicle got totaled out by my insurance company, which is how they ended up back with the vehicle. But then they said I did not hit a deer according to them.
There was an accident with it?
Yes.
Well, what you're proposing doesn't work. If I go to First National Bank,
bam! I told you, y'all, especially like even when you in state court. See, when you go to state, I'm telling you, when you go to state court, you can't go into state court. Like I'm just talking about based on these people's posts. You can't go in state court talking all this high-end accounting stuff. That stuff is like, you got to be a plaintiff in a federal lawsuit. State courts, you got to wedge in the accounting, and you got to slide it in between. You got to argue different. That's what I'm saying. They think all the arguments apply universally. And that's what people get in trouble at. They thinking it's like a copycat. Everything is going to be the same for everybody. And it just doesn't work like that.
I borrowed $10,000.
There's case, and guess what? You know what's so crazy? In my client's case in Ohio, I didn't cite the accounting standards not one time. Because it was a situation where I didn't need to. The situation ain't calls for it. I didn't cite the accounting standards not one time. I don't just cite the accounting every single case. I argue the case based on the facts and circumstances of each case. If this case, calls for, then I will. If it doesn't, then I won't. They thinking online now that it's just gonna be wherever. I just say accounting, you say accounting, you say accounting. These motherfuckers are lost.
To buy a car. I drive it off a lot and I don't like it or it's got issues. And I call the bank and say, hey, I want you to excuse my $10,000 loan because I don't like this car. And by the way, I want to just go take it back and give it back to the car dealership. They won't take it back. You sold it, you bought it as is at high interest rates. The auto dealership.
I'm telling you, and the reason why I'm showing this because I'm highlighting because it gives you a realistic, like the reason why I show this stuff because it puts you right in the courtroom. It gauges on, okay, how can my arguments look? How can I learn from these people? How can I tighten up? I'm telling you, it never works the same that you got it in mind until you step in the courtroom. It never works like that. You got to be able to pivot on it. There may be some of your strongest claims that as soon as you get to court, the judge is going to shut it down off the break. You got to pivot. I'm telling you, you got to find a way to get back in. It's never going to go 100% according to what you've been. No, you got to pivot on a dime. In some cases, you got to adopt a whole new argument right then and there in the moment. What do I know? Experience of being in court.
Are in the business of doing this, and I see poor hapless car purchasers like you in this situation all the time. You're paying for a dead horse. You're paying for a car you no longer have. But apparently the insurance company must have totaled it and given you some sort of a check. I don't know where that money.
There was no check given. They worked directly with credit acceptance. So I honestly am not sure what happened at that point. I believe that it was credit, somewhere between the two. They denied that I hit the deer, but they did agree that the vehicle was no longer usable. And then credit acceptance got the vehicle from the insurance company and they auctioned it off.
Okay, I agree. I believe that. So basically, okay, she said there was, okay, so let me just put it down because I know insurance too. I know insurance very well too, by the way, and that's one of my weakest points, but I know it very well. So they took the vehicle to their insurance company. The insurance company notified credit acceptance that they were denying the claim. So credit acceptance said, we about to go pick that vehicle. Don't give it back to him. We got a lien on it. And then credit acceptance sells the vehicle. And then they sue him to court for the deficiency. What they don't realize is whatever was stated on the contract, I'm going to skip past that. But that's what happened. They denied the claim, let credit acceptance know. Credit acceptance say, hold that vehicle on ice. We coming to get it. They sell the vehicle. Now they sue them. That's exactly what happened.
Credit acceptance did or the car dealer did?
Credit acceptance.
Credit acceptance auctioned it off.
All right, well, that's what happens. Can you advise regarding that, Ms. Hartman?
Yes.
The judge in this moment, he already knows who's winning. He already knows he's going to rule for him, but he's actually just giving a teaching lesson, trying to explain. He's doing all this so they can see how court works. That's all he's doing here. His decision's already made. But he's just he said, can you advise him? He's just basically teaching them, yo, this is how shit goes. It may not be fair, but this is how it works. That's what Jeffrey Middleton is doing, Judge Middleton. That's what he's doing. Court is not designed to be fair. Court is not designed to be fair for everyone who just walks through the door. Court is designed to be fair for those who knows the rules and understands the game. Damn, that was a bar.
You're rocking with the best.
I'm telling you, court is not designed to be fair for everybody that walks through the door. Court is only designed to be fair for those who understands the rules and knows procedures and knows how to make good arguments. That's it.
So as to their story, I don't see any justification for the story, but the car was repossessed and it was sold at auction. And
so basically the insurance denied their claim. The insurance didn't let them know that they was giving the vehicle to credit acceptance because it's really not their job. Long as credit acceptance shows that they have the right to come pick up that vehicle, that's all the insurance company needs. The insurance company never told them what credit acceptance came and got the vehicle. Okay, that's what I assume. So when credit acceptance came to pick up the vehicle from the insurance company, that's when they sold it. Credit acceptance deemed that a repossession.
whatever the amount at auction brought in, it was applied to their balance, and there was a deficiency that was owed.
This happens about 100 times a year.
It happens about 100 times a year. So that's 100 people going into court that don't understand the game. So when I say the less than 1% understands from a consumer standpoint, y'all, there's about 50,000 judgments issued to credit acceptance finance companies a week at my county at the court. because they get the docket printout. And I was going over the docket. 50,000 judgments a week. I mean, the page, it was like day one. Like when I went there, it was yesterday's court hearings. It was like the stack was this thick of all judgments daily. People lose every day. They lose every day. And they think that just because they're in a Facebook group, social media group, and they're following someone that's posting stuff, like they're going to be any different. There are people that are in, and this is the sad part, there are people that are still following people who have took their advice, lost in court, but are still hanging around. You want to know why they're hanging around? Because deep down inside, they didn't believe it anyway. They didn't think it was real legit anyway. So they didn't believe. They're just waiting on the next new thing because they still have hope that one day it can get done. But they don't really believe they're going to be successful. 98% of people in this space does not have the confidence needed to go up against these multi-billion-dollar companies because they still have a economic slave-like mentality. Finance companies up here, we're down here. They may not say it, but you can just tell. Most people have an inferior position to these finance companies and these financial institutions. I look at them and I'm like, let's go. I have no inferior position to none of them.
To me,
I believe I'm right on their level with the knowledge and understanding. I believe I'm right on the lawyer's level.
here in St. Joe County, somebody buys a car from a car dealership. The car has a high price, it has a high interest rate. The lender and the car dealer are taking risk to sell the car to people who don't have a lot of money. Then they get repossessed. They sell the car.
Risk. It's a key word that he said there, risk. Are they really taking a risk? Only if you know.
For substantially less than it was paid for. Let's say the car is worth $10,000. You paid $12,000 for it. The car breaks. You made a few payments on it. The car gets repossessed. They sell it for $4,000. Somebody washes it, puts it on the lot and sells it next time for $6,000. They apply $4,000 to your $12,000 loan and you still owe $8,000 for.
Exactly. They always sell you the vehicle at an inflated price. And when they auction it off, they auction the vehicle at its Kelly Blue Book or Black Book value. So the difference between what the car is really worth versus what they're suing you for is nothing but what's stated on the contract. That's a scheme. That's called a legal scheme. They'll sell a vehicle that's worth $10,000 to you for $25,000. After a time period you had a vehicle, the value drops. They repossess the vehicle. They auction it off about $4,000-$5,000. They bring you into court and sue you for about $5,000-$6,000. Welcome to the United States of America. But when they auction the vehicle off and sell it, they're always selling it at its real blue or black book value.
Car that you don't have anymore. I don't have to like it, but that's how much of this works. So, two issues. You don't have.
So, which I would never make public, have credit acceptance hold internal model. You would never see the light of day of it on here. You would never see the light of day on my social media platforms. You would never see it. You know, but people get that shit and they want to post it and be like, oh, look, y'all, look. I would never expose their internal model. But I got their whole internal model. I know how much your vehicle's really worth. I know how much they really say you owe. I know how much they account for how much you really owe. And I know how much they're about to come after you for. Right. Now this is set in like, okay, I see why credit acceptors left him the fuck alone. I know their whole model. I got it. And that's a model that hundreds of dealers use. The contract amount, it's never what it really is. But but it's not just knowing that. How do you articulate that in court under the legal rules and standards? See, that's the part that people miss. Most people think, well, all I got to do is just go to court and just attach their model to it. Don't look online for it. You're never going to find it. I say it's internal. They don't even make it public. But not for real. That's just one of the perks of being around professionals that's been deep in that field. You get a little privy to certain shit that the rest of the public don't know. I mean, that's just that's just what it is. I don't know what else to say. Like, what the fuck?
The vehicle was a hand-in, it was on a payment plan. It was a hand-in. They did not come here to repossess the vehicle. In fact, my insurance company could not get them to even pick up their vehicle. And finally, that's when it was.
Okay, so what they did was they waited to about 90 days or close to the 90 days, and then they picked it up and called it a repossession. That's exactly what happened. They picked it up and called it a repossession. That's all they did. That's all they did. That's standard. Because if you understand internal financing and accounting and the finance system itself, there's a reason why they'll never pick up the vehicle when you voluntarily surrender it to about 80 and 90 days later. It's a reason.
They called me asking why I didn't have where the vehicle was, wherever my payment is. And I'm like, well, it was given to the insurance company like you guys wanted, and they've been trying to get you guys to come pick it up. So they actually took the vehicle from the insurance company after a longer period of time. And
exactly. So you notice how she's saying what happened, and I'm filling in the blanks on why they do it. So she's saying what's happening, but I'm telling you why they do it. There's a difference. She's telling you what happened. I'm telling you why they do it.
And it was, I believe it was taken from a parking lot, a locked in parking lot that the insurance company put the vehicle at, because they didn't even know what to do with the vehicle, because not only did I not want the vehicle, but neither did credit acceptance at that time.
So what do you want to happen? They just write off this substantial debt? They don't get anything?
Well, so right now, and we tried to pay on it before everything happened. The vehicle was not in any way, shape, or form drivable or salvageable. They refused the vehicle, so they knew that the vehicle wasn't worth anything. And then it was auctioned off a substantial amount, way lower than the rest of the loan. But what payments I don't understand how I'm supposed to pay for this. The SSI that we have are for 2 deaf children, and that is our only income, besides for the fact that my husband does go to school. So I guess you could take his school loan away. I mean, I'm not sure.
Well, they can't do that either. The fact that you're
Yeah, what's going on, Big T Dizzle? I was just
not a whole lot, man. I just had some eye surgery.
Oh, okay. Nah, I was just checking in with you. See who's up with the Top Gun professional. But give me a call back when you get yourself in order.
All right, I'll give you a call Monday.
All right.
I should have my vision.
Yes, sir. Yeah, take your time. All right.
All right, bye.
It's professional, man. Hey, call me back. Yo, if you would just be a fly on the wall to the private conversations we be having and documents we be sharing amongst each other about the internal operations of this shit and some of the shit these top litigators and SEC and account, all this shit that they study and was trained from. I don't understand why you wouldn't join the Supreme Elite team. Like, my Supreme Elite Team University is going to consist of training material that the top people in this field study from. That's a fucking bar.
Rocking with the best. You're rocking with the best.
Let's get to it.
Don't have money is not a defense to the fact that you owe money.
But that's the point. Not having the money is the reason why 90% of people follow these paths.
So they're not going to take your SSI. They're not going to take his.
You can save money for understanding. So let's do 622.96 for 5 months. That's how much understanding saved me. So think about it. If you study from someone that teaches understanding, if you just stop worrying about the goddamn immediate, unless you got the money to pay for the services, don't come expecting immediate help unless you got the money to pay up front. The problem is most people want immediate help and they got the money to pay because they gave all their money to these gurus and shit ain't work. Now, I ran out of money. I'm going through this. I don't care. I'm sorry. I don't care.
School loan payments, but your circumstances could change. You purchased this car, which is a 2013 Chrysler Town and Country. The car was $12,838. You financed at 22.99%.
Golly. Woo wee. Good God almighty, that's a lot.
Loan sharks used to charge 6. This is an extremely high interest rate.
Right there. And I scalped them.
You're rocking with the best.
I scalped them on that argument. Y'all want to see my motion for preliminary temporary injunction relief that's citing the accounting and all that? You want to see it? Join the Supreme Elite Team. There you can see it. You'll never see it on here.
This 11-year-old car, you had $7,390 worth of finance charges on it. And no one forced you to sign that agreement.
Right there. So when you come in with your accounting, this is what the court, right there. If you come in with the accounting based on what they're saying online, that's exactly what the judge is going to say. No one forced you to sign this. No one forced you to do it. Now, pay attention to what they're going to try to bring up. Core elements. They're core elements, but watch.
And you signed it, and it's a contract, and it binds you to the terms of the contract. And it clearly says this vehicle is sold as is. And so, as I said, I see this dozens of times a year. You also apparently purchased some sort of extended warranty for an additional $2,000. I don't know what the status of that is, but the company was Gazelle Auto in Sturgis. This plaintiff is simply the people that lent you the money to buy the car. And so when you defaulted on the loan, they repossessed the car, they sold it. And so I find you have not stated a legitimate reason for failing to appear, and there is no valid defense. It's an unpleasant, big, ugly, bitter pill, but the motion is denied.
My motion wasn't denied. I'm sorry, my complaint wasn't denied. And it's the same company. and their operations are their operations. What's the difference between me and them? Because I'm me and they're them.
You're rocking with the best.
Yeah. You're supposed to pop your shit when you went through the ringer and took the years it took and did all the sacrificing you did. You're supposed to pop your shit. Don't ever let nobody shame you into popping your shit when you put the work in to be able to pop your shit. And listen, they want to follow people who doesn't show results, because show results make them feels bad. Then they start to envy. Y'all, these spaces are filled with haters. You would think that they want to deal with people that has results. They don't want to deal with people that has results. That's different from what they believe and understand. No, this space is filled with haters. The patriot movement, sovereign community, whatever community that all this is filled with haters. They will personally see your page and see your results and be like, damn, I want that too. How he get it, not me. And I didn't even go to school for this, all self-taught. Hey, I'm not saying I'm better. That's how they really feel that I am. Oh, they know I'm better than them. Oh, they know it.
So they also said under the.
I'm better at accounting, securities laws, investor laws, lawsuits, motions, complaints, responses, arguments, pro se litigation. Nobody in this space can match me in pro se litigation. I got like 10 things. Oh, and I can teach effectively with black and white results that changes people's mindsets. It's 10 things that I'm better than these gurus at. Let's not forget now. Let's not forget. Hold on. Make sure you don't, I don't want you to forget. Hold on. I don't want you to forget. Let's not forget now. That's what they coming with. That's what they coming with. But when you like that, you'll start to get responses like this. Thank you for reaching out with your concerns. It appears that as of August 25th, you filed, but not yet served, a suit against credit acceptance. While we work diligently to provide investigations and timely responses due to the pending litigation and to ensure the parties' positions remain consistent, we respectfully decline to discuss any further details related to the concerns that you raised in your letters. Due to the pending litigation. Your gurus will never get a letter like that. That's basically saying, hey, we ain't fucking with you right now. Your gurus would never get a letter like that. Your gurus would never get a letter like that. Your gurus would never get a letter like that. Trust and believe, they'll never get one. The letters that they get, they'll never show y'all because it's a rejection letter. Oh, shit. They'll never show you. They won't show y'all the rejections.
Civil case that there is no other pending or resolved civil action arising out of the same transaction or occurrence as alleged in the complaint. And that's the other thing. There is and there was another lawsuit against credit acceptance, not for just this vehicle that I had, but also a prior vehicle many years back that the other attorney,
Now you want to bring up a lawsuit because they charge excess interest. Oh, excess interest in court. That's another buzzword.
Bring that up or find the paper and send that to you. Already closed out, and I will actually be receiving a settlement back from them.
That's a different lawsuit, ma'am. That's not relevant to this case.
That's not.
Told you, steamroll right over top of it. Hold on, I already won the settlement against them, so y'all better back away now. Steamroll right over top. I told you they're just going to steamroll right over your arguments.
This case.
Even though this vehicle was included?
No, they
In
would
the
be
earlier
two separate
lawsuit?
debts.
You're saying this vehicle was included in an earlier
Correct.
lawsuit?
Yes, Your Honor.
Judge, I have been working credit acceptance files for at least 10 years. They don't combine cars, they don't combine debts. Each debt and each car is separate and
There you go. Each debt in each file is separate, meaning they're going to treat one claim my way, and they're going to treat the rest like these social media teachers. That's all they're saying. Everybody's not going to get the same treatment. So you 40, 50,000 people just stockpiling to one group thinking every single one of y'all are going to get the same thing. You're lying to yourselves.
distinct, especially if it's in two different law firms. So whatever lawsuit she's referring to or whatever attorney's office she's referring to is not relevant and very distinct from the debt for which we're here for today.
And that's exactly what they're going to do for you as soon as you bring up your accounting in court. With social media, that's just all they're going to say. Your Honor, it has nothing to do with the contract. Your Honor, they cannot raise it as defense. They're not a party to the transaction. Oh, man, I can't wait for this.
I mean, I can't go and say another lawsuit was filed for another car that's not my law firm. Like, I can't put that on the summons. It's not the same car. It's not the same debt.
It's the same car and the same debt. It's due to the fact that I was overcharged with interest and you guys were.
Oh, overcharged with interest due to the fact that I was overcharged with interest. She brought that up in court. I brought that up in my complaint. Let's see. Since she brought it up and I brought mine up, since she brought it up, it's supposed to stop everything in its tracks.
Were sued for the wrong charges that all of us have received. Both
We're going around in
All right,
circles
all right,
here.
all right.
Are we done?
I don't see another credit acceptance case.
Through Lantern Attorneys, Lebanon and Keller, they have
Well,
actually my settlement.
who sued you?
I was not sued. We all there is a sue on credit acceptance, and that was already had just actually went through,
Yeah.
and that
All right,
included
that's-
both of my vehicle loans.
All right, that's not relevant to this.
Bam. They were sued, including mine. Excess interest. Steamroll right over top. Want to know why? I'm telling you, because it's not designed. I don't know how many times I gotta say it. The system is not designed for every consumer to win. The lawyers, proper attorneys representing you, yeah. Pro se consumers, very little wins. And it's designed that way. It's not designed for every pro se litigant to win. I'm telling you. I'm gonna tell you something professionals told me and what I've seen. Prime example, when I was in court like almost 2 weeks ago, I was the only one that made it to the next phase out of everybody that was in the courtroom that day. Everybody else lost but me. Out of, let's say 250,000 cases, roughly, could be lower. Maybe 1 or 2 are going to win against these people. Maybe 1. Out of 1 million cases, maybe 5, 10 will win. And that's worldwide, including people that are in these groups. That's worldwide. Because the system is not designed for everyone to win. That's the harsh reality. I'm telling you, some professionals told me it's not designed for everybody to win.
She's correct. There was no other lawsuit that included this vehicle in it.
Told you, did this steamroll right over top of the excess interest lawsuit. The judge didn't even, he just ignored it, whatever. Even if you was to go to court and say excess interest, or they're going to say, just say, hey, you shouldn't have signed up for it then. What do you say then? Because the courts have an obligation and duty to protect the right to contract and enforce binding contracts. It has to be extreme circumstances where they look beyond the contract. And that's not going to happen every day. It happened once, probably like once out of every a million pro se litigants. It may happen once out of a million cases.
That included the vehicle loan, and they just offered me a settlement on that vehicle loan that I have already accepted.
All right, good. That's a different.
Bam! Steamroll right over top of it. You think they give a shit about that? And this is why consumers think that y'all can just go to court and say buzzwords and that's going to stop everything. They don't care. I'm telling you, they're going to roll right over top of your consumer arguments. They're going to roll right over top of them.
Different vehicle.
No.
All right. Well, you haven't pled it. Yeah, I don't have a file number. I don't have anything. It's like, oh, by the way, there was another lawsuit with such and such and such and such. You have a right to appeal this, but I found that you have not complied with the court rule that would allow this default judgment to be set aside. So this matter is completed. I've got about 20 people waiting. You can appeal this. You can seek further legal assistance, but you signed this contract, which was very onerous, and you're bound by the terms of it. I don't have to like it, but that's the way it is.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. You're going to learn how to act in a courtroom.
Can you hear it? Can you hear it?
Let's play that, and let's play
This contract.
Let's play back for everybody who's lining up to be put right in the blender of 2026 with their accounting claims.
Which was
Let's
very
go.
onerous, and you're bound by the terms of it. I don't have to like it, but that's the way it is.
Are you kidding me?
Oh my God.
You have
Everybody's
got to
going
be
to lose
kidding
in
me.
2026.
What is going on today? This is a joke. This is a joke.
So everybody's going to lose in 2026.
Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. You're going to learn
That's all the repossessions and foreclosures in 2026. Let's get a shout out to all the repossessions and foreclosures in 2026.
He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Gonna get your
Oh my God, sir, put that cigarette out. I don't give a
and your car's repossessed.
crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people.
Because you want to just copy accounting that you don't understand.
You're going to learn how to act in a courtroom.
Can you hear it?
And run into the Supreme Elite team screaming for help when your car is repossessed while you're at the store and you come out and your vehicle is gone because you kept playing games with the accounting and they kept saying it's not legit and you kept arguing. Then you set the negotiable instruments because you got back into your sovereign citizen ways and they come took your vehicle. Now you got no way to take your kids to school and get back and forth to work.
This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. You're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am?
Right after the finance companies taking their shit.
Ma'am? Can you hear it?
Okay.
Take that shit.
No case. Trust me, at the end of the day, I'm sitting up here, I'm the one that needs the drink.
Woo! That was good.
Distinguished Mr.
That was good. That was a good one. That was a good one. Cause they come take your shit. Don't be mad. Come on, man. Everybody get this shit taken sometimes. Listen, there's nothing wrong with getting your shit taken if you learn the lesson. I mean, this person got their shit taken and they cited accounting. Oh, we have an accounting securitization claim here, don't we? Uh-oh. And guess what? This was for like 2012, 13. And they cited accounting and mainly securitization. They cited it here way before these people online starting to know. Now, who's the defendant? Now, look at here. You got the plaintiff, the borrower, defendant, Chase. Now, what is this right here? Order granting defendant's motion for partial summary judgment. Uh-oh, you get a partial. Okay. Now, I don't want the finance companies to really come take this shit. I'm just joking. But I know they're going to take this shit, so. Oh, they're not playing. You start sending them stupid ass letters to them, they're not going to keep going back and forth. They're just going to, this is what they're going to do. You keep sending them dumbass letters to them not making sense, they're going to write off the account, come snatch your shit, sell it for pennies on the dollars, and then sue you for the rest. That's all they're going to do. They do it every day. All right, let's go ahead and zero this account out. Go take this shit. Go sell it. Sue them for the rest. That's extra money for us. Listen, I don't make the rules. I just follow protocol, baby. Defendant JP Morgan Chase Bank moves for partial summary judgment on plaintiff's Javahari's second amended complaint. The court has carefully considered the arguments in support of and in opposition to JP Morgan's motion. For the following reasons, JP Morgan's motions is granted. On November 14, 2007, Javahari obtained a $2,666 million mortgage from Washington Mutual Bank to finance his property located there. This was at a time, but they was just giving money away. In connection with the loan, Javahari executed a promissory note and deed of trust encumbering the property. The deed of trust identifies Washington Mutual Bank as the lender and Chicago Title Company as the trustee. Javahari asserts that as in November 2007, Washington Mutual transferred the note to Washington Mutual Mortgage and Securities Corporation. Securitization. There is no evidence of this. Uh-oh. Javahari also alleged that the note evidence of indebtedness was sold as an investment security to unknown private investors. Isn't that what y'all tell them to? Isn't that what y'all tell them to look up and talk about and bring up, chain of title and yada yada this and yada 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 that? Javahari identifies this security as Standard & Poor's CUSIP number, pool number. Oh, he has the CUSIP number to the securitization. He has the pool number to the securitization. Hell, he probably paid $1,500 to get an audit and probably saying, look, Judge, look at this audit. This is what they're doing. Uh-huh. Look at him. All you securitization people, look at you. Uh-huh. Javahari took this pool number from the deed of trust and entered it into a pool talk form on the Fannie Mae website. But the number of the deed of trust was handwritten and read 4325-5-14. JP Morgan maintains that the number on the deed of trust corresponds to the assessor's parcel number. The assessor's parcel number is 4325005014. On September, look, he got that all wrong. On September 25th, 2028, the Office of Third Supervision closed Washington Mutual and appointed the Federal Deposit Insurance Corporation as receiver. I was wondering how they fucking fell apart. Washington Mutual, I remember them. Boy, they was scalping the shit out y'all pro se motherfuckers coming into court. Washington Mutual was spanking them. JP Morgan acquired certain of Washington Mutual's assets by entering into a purchase and assumption agreement with the FDIC. That transfer and assignment, when the bank fails and the FDIC appoints receivers and finds a company to buy the assets, if you try to say chain of title, you're going to lose. That's a government issue there. You're going to lose. You lost. JP Morgan is your new lender. And the receiver, FDIC, you would never win that argument. It's over with. You're going to lose. It's a government issue now. Notwithstanding Section 4.8, the assuming bank specifically purchases all mortgage servicing rights and obligations of the failed banks. JP Morgan has a legal right to service now and collect. Yep. I don't give a shit what you believe. Yep. In March 2010, JP Morgan sent Javahari a notice of collection activity letter stating that he was in default of his mortgage because he had not made any payments since November 2009. Javahari's attorney at the time responded to the letter requesting all future communication related to the loan be conducted through his office. On May 3rd, 2010, California Reconveyance Title Company was substituted as trustee for the loan in place of Chicago Title Company. Oh, you know what that means? When you start to see moving like that on the recorders, they're moving to foreclose. What was this? May? They did that in May. They're moving to foreclose. They're positioning themselves to come take your shit. Hey, Thomas, what's going on? Hey, I seen them. They did a substitute of trustee. I said, uh-oh. What does that mean? They're about to come take your stuff. It does? Yeah. So you gotta let me know what you trying to do. All right, I'm gonna do some more research on it. You can do all the research you want. They're about to come they're about to file foreclosure. It's gonna be that notice of default foreclosure lawsuit. That's exactly how it goes. 2 hours later, I'll get your service now. I do see the notice of default filed. Yeah. People are going to wake up, but the sad part is they're going to wake up when it's too late. They're going to wake up when it's too late. Also, on May 3rd, 2010, CRC recorded a notice of default in election to sell the railroad property in Los Angeles County Recorder's Office. Same day. Same day. On May 14, 2010, CRC recorded a notice of rescission and a second notice of default. CRC then mailed the second notice of default to Javahari on about May 24, 2000 and again on June 8, 2010. On August 16, 2010, a notice of trustee sale was recorded and subsequently served on Javahari, published in the local newspaper and posted on a well-worth property, and you're in a non-judicial state. Yo, we was able to scout Navy Federal, and they was in a non-judicial state.
You're rocking with the best.
We are just so different. Like, people come to me stressed out, but as we talk and go over their plan, they be so relieved and confident. Like, oh, I see what you say. Oh yeah, let's get them. They coming in. Next, like, I'm ready to go. Exactly. Shout out to you. Exactly. Now you see. Oh, once you see, it's actually like real easy. Like, oh shit, it's been like this the whole time. It's not even that difficult. Once you see it, it's like, damn, it's been in my face for 30 years and I didn't even know it existed. As a result of these events, on October 29, 2010, Javahali filed a complaint in this court against JP Morgan and CRC. Both Javahari's original complaint and his subsequent first amended complaint were dismissed for failure to state claims. Oh, he's not the only one. That's going to be everybody else in 2026. Don't worry about it. That's going to be everybody else. On April 12th, 2011, Javahari filed his CAC, second amended complaint against JP Morgan. Oh, they forgot to put a space there. Oh, no, they didn't. JP Morgan filed a motion to dismiss, which the court partially granted, leaving only claims for violation of California Civil Code section, wrongful foreclosure, quasi-contract, quiet title, and declaratory injunctive relief. Those are pretty good claims to have preserved. Good job. On December 5th, 2011, Javahari filed a complaint in another action that was nearly identical to the SAC in this case, except that it concerned Javahari's condominium in Wilshire Boulevard instead of his house in Wellworth. Damn, Javahari. Due to these cases' similarities, the court consolidated the later filed case regarding plaintiff's condo, which was with this earlier filed case concerning the Wellworth property. On June 21st, 2012, JP Morgan filed a motion for partial summary judgment as to the remaining claims from Javahari's SAC. JP Morgan's motion pertains solely to the Wellworth property originally associated with the case number. Legal standard. This is the part where most people want to skip over. It's too boring, but this is why people lose. Because this boring shit is what I take an interest in. That's why people lose. Summary judgment is appropriate when after adequate discovery, the evidence demonstrates that there is no genuine issue as to any material fact and the moving party is entitlement to judgment as a matter of law. Federal Rules of Civil Procedure. Oh, they'll never read that. Their heads are spin. Do you really think if I said, hey, everybody, all y'all students, this is what I read. Students, this is what I read and studied. And this is what you have to read and understand. That, number one, you gotta read that. And this is the actual district court local rules. Look at this. Rule 8. What was down this? We're at Rule 11, Rule 12, Rule 13, 15, 17, 21. What is Rule 22, Rule 24, Rule 25. New cases, attachments. Rule 26, Rule 27, motions. Wow. Accompanied documents. An application for an order or other relief is made by motion unless these rules prescribe another form. Motion. So, we don't make motions. We don't plead. But you're stepping into the court. Are you constitutionalist sovereign people? Made by motion. A motion must state with particularity the grounds for the motion, the relief sought, and the legal argument necessary to support it. Not your vapor money theories, not your modern money mechanics theories, not your, hey, according to the accounting standards, you did got to do this. Any affidavit or other papers necessary to support a motion must be served and filed with the motion. An affidavit must contain only factual information, not legal argument. See? They don't even know how to follow the rules. Look, this is all what you got to learn. See, this is what I studied. And you wonder why people don't get relief. because they're mentally lazy. Oh, that's too much. I know I can find somebody that got a packet I can just send in. Let's get past the legal standard because y'all don't care about that. Let's get down to the meat and potatoes. Let's get down to the meat and potatoes. Wrongful foreclosure. Javahari claims for wrongful foreclosure relies on three contentions: that JP Morgan is not the owner, holder, or beneficiary of the note. Uh-oh. Ain't that what they tell them to argue on social media in their debt validation claims? Uh-oh. Uh-oh. Ain't that what they tell them to do? 2, that JP Morgan does not have the authority to foreclose. Uh-oh. That the signatures of Deborah Brignat were robo-signed. Ownership of the note. Javahari alleges that JP Morgan did not own his note and therefore did not have the right to foreclose. The second amended complaint states that Washington Mutual transferred the note to Washington Mutual Mortgage Securities Corporation in November 2007, and the note was then sold to an investment trust. To support this condition, Javahari purports to provide evidence of the sale. The number 4325-5-14 is handwritten in the margin of the deed of trust. In 2011, counsel for Javahari entered the number as a pool number in the form titled Pool Talk that was publicly available on Fannie Mae's website. But the numbers that counsel entered differs both in form and substance from the numbers written on the deed of trust. It includes neither the dashes nor the last digit. The only information available in Pool Talk form is the pool number 432551, corresponds to the QSIP number 31379QXC2. And as of 2011, the status of the security was preliminary. Go file a tax return on that. Remember? Go file that on a 1099-B, and then what they tell you, go put the mortgage amount as the withholding. Yeah, you'll get a check that way. Yeah. You'll get a big old fat check that way. You get a big old fat check that way. JP Morgan's explanation for the number 4325-5-14, handwritten in the margin of the deed of trust, refers to the assessor's parcel number for the Wellworth property. The assessor's parcel number for the Wellworth property is 4325-005-014. The parcel number and the handwritten number of the deed of trust are the same and in the same format, except the handwritten number omits the zeros contained in the assessor's parcel's number. Ordinarily, summary judgment cannot lie when there's a genuine issue of material fact. But if the evidence is merely colorable or not sufficiently probative, then the court may grant summary judgment. Only if genuine factual issues may reasonably be resolved in favor of each party should the case proceed to trial. Where the record was taken as a whole cannot lead to a rational trier of fact to find for the non-moving party, there is no genuine issue for trial. Here, no reasonable jury can conclude that Javahari's note had been sold as part of a securitization trust. Remember, they say argue securitization when you're being sued. Go argue. Just go argue it. I mean, we're not saying argue it the way we do it, because like we're different from everybody else. But you get my point. The pool number was only a partial entry of what was written in the margin. And the only possible connection to some heretofore unnamed private investors is that the number entered into a Pool Talk corresponds with the QSIP number that had a preliminary status in 2011. Several months after the lawsuit has originated, in at least 2.5 years since the note was allegedly sold as a securitization trust. While the number written on the deed of trust bears a striking resemblance to the numbers associated with the securitized trust, plaintiff simply fails to produce sufficient evidence to establish that this is anything more than a weird coincidence. Uh-oh. The court further found that Javahari has failed to establish that JP Morgan does not own the note in deed of trust. But I thought they said all you got to do is just say securitization. That's going to stop it all. Javahari argues that JP Morgan cannot produce the original note and that there's been no recording of the beneficial interest in the note to Chase. Hey, that's another thing they tell you to say. The SAC states neither WAMU, Chicago Title, CRC, nor Chase has recorded a transfer of beneficial interest in the note to Chase. Javahari is correct in this assertion. And JP Morgan offers no evidence to counter it. So think about it, because that is a true statement. There's no recording of beneficial interest in the note. They never do. They never record the note at the recorder of deeds. It's just a deed of trust. We know that. But this argument bears no weight on JP Morgan's authority to foreclose. Told you. You think it's going to stop it?
You're rocking with the best.
Told you. You thought that was going to stop it? You thought that's going to stop it? You thought that's going to stop it? Oh, you thought I was going to stop them? Oh, that's going to stop it. Right. California courts have routinely held that a transfer of assignment of a debt does not need to be recorded. And it's not just California, it's all over the world. All the courts are consistent on this.
You're rocking with the best.
Oh no, these are all the same claims that they argue accounting, argue securitization. And look, Herrera versus Federal. And look, another case here. Fontenoy versus Wells Fargo Bank. Javahari also argues that JP Morgan cannot produce the original note. This is also true. Hey, ask for the original note. If they can't produce it, there's no debt, right? I ran across a post with the teacher was selling a packet explaining how to argue produce the note. So imagine if they take the package, go file it, it don't work, they get foreclosed, then they go to court making these arguments. Nevertheless, numerous courts have concluded that production or possession of the original promissory note is not necessary for non-judicial foreclosure under California law. You're in a non-judicial state, that is your ass. The court agrees. Therefore, although JP Morgan cannot produce the original note and has not recorded the interest in the note, these actions are not required for non-judicial foreclosure in California and thus are in opposite of Javahari's claim for wrongful foreclosure. Bam! Robo signing. That was from back then. They tightened all that up today. Javahari's claims for causing contract alleges that JP Morgan unjustly enriched when Javahari paid in monthly mortgage payments because JP Morgan was not the owner, lender, or beneficiary of the note. Isn't that in the debt validation claims that they're peddling online? In his previous order, the court denied JP Morgan's to dismiss the quasi-contract claim on the basis that if indeed JP Morgan did not own the note, yet received payments therefrom, those payments may have been received unjustly. The court premised its decision on Javahari's well-pleaded allegations that JP Morgan was not the right owner of the note and so that unjustly enriched by collecting mortgage payments from Javahari. Well-pleaded allegation. Past that threshold. Well-pleaded. It's not what you say, it's how you plead it. Those allegations were sufficient to withstand a Rule 12b6 motion. Exactly. They are. Because I will plead this all the time. So let's give a But to withstand summary judgment, Javahari must provide admissible evidence demonstrating that the note is owned by another entity. And that right there is where 99% of people are going to fall apart. That's where they fall apart. Javahari has not done this. And so the court has already concluded Javahari's failed to establish that JP Morgan is not the rightful owner of the note because they never disclose who owns the note. Why do you think they do that? They never disclose who owns the note for real. It goes into a pool, but that's it. They never make it public. So when you know someone that can find that out, well, how they do it? Supreme, when they do it, elite knowledge, one eye. Guess what? It ain't even hard to find it out. You just gotta read hundreds of pages. You'll find it. Javahari does not argue that the note and deed of trust are not valid documents as to the subject loan or whatever property. He argues only that JP Morgan is not the valid owner. These documents are thus controlling and establishing the respective rights and obligations between Javahari and JP Morgan. There you go. He loses that argument. The note instructs the borrower to make monthly payments to the note holder. The note holder is either the original lender, Washington Mutual, or anyone who takes a note by transfer who is entitled to receive payments under the note. The note was properly transferred from Washington Mutual to the FDIC as the receiver of the bank, and from the FDIC to JP Morgan through a P&A agreement. I said once a bank goes over, the FDIC becomes receivable. When the FDIC transfers the note to someone else taking on the assets of the failed bank, you will lose that chain of assignment argument 100 million times out of 100 million times. You'll never win that argument because it became a government issue at that point. And the government ain't gonna let y'all get out on it like that. Oh, you'll never win a securitization argument against the government. Oh no. You know, it's kind of like, all right, so the government is like, motherfucker, we make the rules. We allow these rules to operate. You'll never win against us. It's like you'll never win against that Federal Reserve. Like, motherfucker, we print y'all fucking money. We control y'all money supply. How you gonna beat us? You'll never beat us. And you'll never beat the government in this. I don't give a damn if it's illegal or not. You'll never beat the government. You will never. I don't give a fuck if you got black and white evidence. You'll never beat them in this. You'll never beat them. I wouldn't even advise. You would never win that. I'm sorry. You never will. Too many people tried. And too many people have black and white evidence. You'll never win. The moral of that story means pick and choose your battles wisely. Even if the court find that there was no enforceable contract governing the parties' rights and obligations in this case, there's still no evidence that JP Morgan has unjustly benefited from Javahari's mortgage payments at Javahari's expense. Told you. I told you. And he brought up securitization, illegal notes. All right, hold on. Now, oh yeah. So, bam, grant summary judgment. Now let's get to the accounting. Let's get to an accounting right quick. Let me pull the case up. Let me get to the accounting right quick. Actually, let me go LIVONIA. Versus Farmington Road Holdings. Can I get Okay, so we have another one. Livonia Properties Holding Inc. plaintiff and appellant, Farmington Road Holdings LLC defendant. Plaintiff Livonia Properties Holding appeals the district court denial of a request for preliminary injunction of the foreclosure by advertisement of 4 properties which Livonia had defaulted on in its mortgage obligations. The district court denied requests for preliminary injunctions after determining that Livonia did not have a strong likelihood of success on the merits. Livonia was not likely to suffer irreparable harm without injunction. Any harm caused to Livonia by refusing to enjoin the foreclosure did not clearly outweigh the harms to others that would be caused by enjoining the foreclosure, and an injunction would not serve the interests of the public policy. An evaluation of the preliminary injunction factors shows that the court did not abuse its discretion. Livonia owns or recently owned 4 commercial properties in Livonia, Michigan. In December 2004, they used this property to secure $16,300,000 commercial loan with Lehman Brothers Bank. Oh yeah, this is way before because Lehman Brothers went under. Yo, I had the whole study. Oh my gosh, but y'all see the professional. Oh shit. Well, y'all see the professional documents that I have with regards to this. Yo. And it's not just court case I look up. It's not just accounting. It's not this. I read like stuff from like Michigan Law Review, William and Mary, Harvard, Yale, Florida University, Florida State, economics, professors, publishers, they put out a whole like manifestos on corporate like all the professionals in the world. Then I watch documentaries, I watch DVDs, I sit in like classes that they post online, and they was teaching the top collateralized debt obligations, and they film it from a college class, a professional teaching live. I sit right there and take my notes. Lehman Brothers executed the assignment of the loan on around January 6, 2005, effective January 11. The assignment document shows that the loan was transferred from Lehman Brothers to the LaSalle Bank National Association as trustee for the registered holders of LBUBS Commercial Mortgage Trust, Commercial Mortgage Pass-Through Certificate Series Trust, Securitization. The public record shows only assignment from Lehman Brothers to the trust. However, Livonia has produced evidence that the first assignment was actually accomplished through a series of interim short-term transfers rather than direct transfers to the parties. The transfers have been acknowledged by defendants, Farmington Holdings, Lehman Brothers to Lehman Brothers Holding, then LBHI to Structured Asset Securities Corporation. Livonia discovered these interim assignments through an internet research that revealed a pooling and service agreement. They took those down. You can't even find them more. You used to be able to find your property. No, they took it down. Describing the intern and you want to know why they took the PSA down? You can't find your properties. You can't enter on Edgar because this is what you do. Hey, everybody, go on Edgar, put your property in. You can find out who owns your note. Hey, everybody, go online and do it. Hey, oh, thank you so much. Thank you so much. Let's put a heart and a like and an emoji. Thank you so much. You're doing God's work. You're showing us the way. Thank you. And you didn't even charge us one dime to do it. Thank you. And look at the person. Ooh, look, ooh, I'm important now. Ooh, they like me. I'm important. They're praising me. Ooh, I'm important. I'm important. Psst, hey, too many people are asking, looking for their properties, trying to go in the court, make an argument. Hey, SEC, too many people are coming in there trying to use Edgar to find their properties to use it in court. Can y'all shut it down? Hell yeah, shut it down. That's it. That's all they do. Now look at you. Now look at everybody. Anchor doesn't work anymore. Anchor doesn't work. Anchor, I can find my property. I can't. This is why that's why I don't hold classes publicly. You think I'm gonna be out here teaching for just for people to be like, oh, thank you, new coach. fucking up my bottom line. Nah, I'm not here to save the fucking world. It's not my job to save the world. Can't save nobody that ain't got a vested interest in saving themselves. She discovered these. Farmington acknowledged at oral argument that first assignment was executed in blank to be completed later and was completed to identify the trust as Lehman Brothers assignee. On February 10th, 2000. Okay. Forget all that. On appeal, Livonia contends that Farmington is not in compliance with the statute's requirement that a foreclosure mortgagee who is not the original mortgagee must hold a record chain of title to the property in question. The basic assertion is that because the intern transfers in 2005 were never recorded, the chain of title is defective and Farmington cannot foreclose on the properties by advertisement. The district court correctly determined that Livonia did not have a strongly likelihood of success on the merits of its record chain of title claim and dissolved the temporary restraining order. Livonia next filed a motion for reconsideration, which the court later denied. Farmington has sold 3 of the 4 properties pursuant to the foreclosure by advertisement statute. Livonia now appeals. In an initial matter, Farmington contends that Livonia's request that the sales have already occurred be set aside is not properly before this court. Farmington argues that the request was not before the district court in the motion for preliminary injunction, but Farmington does acknowledge that the TRO barred foreclosure, so there were no sales for the district court to set aside. All of the relevant issues of law required award to either for relief, an injunction, or avoiding of the sales were presented below, and Livonia has not modified those claims on appeal. She don't even know the court, don't even know the court rules. Look, losing on the court, look, court procedure. Court procedure. 1 second. Put this heat on. It's getting cold as a bit.
No pressure, nah. I ain't feeling no pressure. No, I ain't stunting her, man. She wanna get on top of shit. I'ma let her. With this street code, I abide to the letter. It's just me against me. I ain't feeling no pressure. There's no hoes barred with the shit, nigga. Everything gon' go. Hoes come to see me. I miss a heart and hustle up with the flow. I used to stand in the crowd, but now I'm the star of the show. My 10 in the field of play. I know you niggas looking down at my toes. I'm only smoking no pressure. I'm digging graves with the shovel. Just like Pac in my nigga bags. You should know Liddy be a rebel. They watch the corner for a stat. Watch out. My little nigga be the lookout. You broke that shit embarrassing. Like the drunk uncle watch the cookout. My 10 down, you got a foot out. I fuck a bitch, never pull out. A bitch drowning my drip flicker. She gon' feel the stain from my wrist. You disrespect on that click. I put the tech on your lips. No handouts, they gon' go get it lit and cut a check for a quick. No pressure, nah. I ain't feeling no pressure. No, I ain't stunting her, man. She wanna get on top of shit. I'ma let her. With this street code, I abide to the letter. It's just me against me. I ain't feeling no pressure. There's no hoes barred with the shit, nigga. Everything gon' go. Hoes come to see me. I miss a heart and hustle up with the flow. I used to stand in the crowd, but now I'm the star of the show. My 10 in the field of play. I know you niggas. Yeah. I ain't feeling no pressure. I do this shit in my sleep. I treat the hoes like a dog. While the bitches on a leash. I open up my palm. Then tell the niggas come and eat. I got a kiss in my hand. Can't tell me I ain't no peace. Let it count his blessings. No, he.
Bring that one back from the top. You're rocking with the best.
Where'd I leave off at? Farmington also contends that Livonia's petition is partially moot because 3 of the 4 properties have already been sold through the foreclosure by advertising process, but this argument is also without merit. Farmington's sole support of his position is a quote taken out of context from Wright's Federal Practice and Procedure treaties, which states if the district court has denied an injunction, there has been no state defendant free to take action sought to be enjoined, and if the event sought to be enjoined transpires before the appeal is heard, the appeal will be dismissed as moot. Motherfucker, that ain't the court rules. That's someone's take on it. We have found no additional support for this proposition, and Farmington has now argued that we will be unable to provide Livonia any relief in this appeal. The key issue on appeal is the meaning of record chain of title under Michigan's foreclosure by advertisement statute. The relevant language is if the party foreclosing a mortgage by advertisement is not the original mortgagee, a record chain of title shall exist prior to the date of the sale, evidencing the assignment of the mortgage of the party foreclosing the mortgage. Livonia contends that because the PSA pool and servicing agreement was never recorded and two parties to the PSA are not reflected in the recorded documents, the record chain of title requirement is not satisfied. Livonia's basic assertion is that a Michigan mortgage may only foreclose by advertisement if every intern assignment between the original lender and the foreclosing party is revealed by the public record. Livonia's interpretation, however, is not in accordance with the case law. I was just about to say, that's why I want to continue to read that part. When she made that argument, it's supposed to be followed up with, see such and such verse this, see such and such verse this, holding that a original mortgagee that didn't have the chain of title is borrowed from it. See this case, see this case, see this case. Other circuits have concluded the same. So you got to substantiate your arguments with legal, factual case law. But y'all know what happens when it comes to case law. There is most likely no case law governing the county. Y'all see what happens. Livonia offers no definition of the term record chain of title. See, I would have had all that. What does it mean? Break it down. Have other courts use the terms. Have other professionals use the term. What is the normal standard meaning in the professional setting? What does the court say about this? Find a case where the court's ruled in my favor. Find this case, this litigates this thing. See, they don't, nope, none of it. It interchanges the phrase with chain of title throughout its brief. A search of Michigan case law and properties treaties has not revealed a definition of either term, but the phrase is plain on its face and was reasonably defined by the district court in its opinion and denying Livonia's motion to reconsider. Record chain of title is comprised of documents that were filed in the county register. So if Livonia was actually smart, Livonia could have stated new precedents. Livonia could have set new precedents if she would, if the company would have worded it correctly. Hold on, because let's get to the. Hold on. Let's get down to it. Okay, watch this. This is going to be the hallmark of what they're teaching online. Livonia asserts that Farmington must prove that the assignment between Lehman Brothers and the trust is legally valid in order for Farmington's chain of title to be valid. Livonia contends that the assignment from Lehman Brothers to the trust may be invalid because the trust did not actually exist as of January 6, 2005, the date entered on the transfer instrument. Livonia bases this claim on the pooling and servicing agreement, which created the trust but was not executed until February 8th, 2005. Remember, find their pooling and service agreement, find their indentured agreement, point out, look, they didn't do this according to their indentured agreement. Remember, that's what they say online today? Ain't that what they say? What have I been saying? You cannot go into court and argue anything regarding the indentured agreement, the pooling and service agreement, the sales agreement. You can't argue none of that. You cannot use it as a defense. The argument as articulated on appeal is that the trust can have actually received the mortgage on January 6, 2005, and as a result, the assignment was invalid, making the record chain of title invalid. And they make these same arguments today. As a preliminary matter, Livonia has presented no authority for the proposition that the record chain of title is destroyed by an irregularity affecting the validity of the transfer. No case law, no supporting arguments. When you look at my motions, well, if you ever see them, well, you're only seeing them in my Supreme Elite Team group. But if you were, let's just say everybody's in the Supreme Elite Team group, you will understand that every argument I make is supported by relevant and authoritative case law. Meaning, you mean you got a case law that points out everything you said about credit acceptance is true? You got case law to back up every little thing? Because they take people to court all the time. You mean you got something that can hold their feet to the fire? Of course. About 40, 50 cases I cited in my 225-page complaint. What's the big deal? It's only 225 pages. All typed by hand. What? It's 225 pages. Y'all like it's 500. Even if the transfer were invalidated, the public record will remain as it is, and the record chain of title would not be disturbed. Regardless of this point, even if there was a flaw in the assignment, remember they tell you to argue the assignment. There is no chain of title. You can, or they can lose. No chain of title. It's argument. It's over with. It's done. Look, all you got to do, get this securitization packet. Argue chain of title. That's all you got to do. That's all you got to say. As a matter of fact, hold on, y'all. As a matter of fact, let me show you exactly what I'm talking about. I'm going to show you exactly what I'm talking about. No, I'm going to show you exactly what I'm talking about. I'm going to show you exactly what I'm talking about, where 99.99% of these teachers have no clue as to what they're talking about or what they're advocating for, because if they did know, then let me tell you why I say they don't know. Because if they would have actually read case law based on the things that they're talking about, they would have stopped what they was doing in their tracks and say, no, this is not legit. But you notice that they will never do that. Want to know why they'll never do it? Want to know why they'll never do it? Because the problem with people, with these teachers, and I've noticed this with a lot of them, that most teachers just want to be right. They don't really care about getting the job done for you. They just want to be right on camera. And I'm not lying to y'all. Oh, let me pull it up now. Y'all, they just want to be right on camera. They just want to be right on camera. And all these people that be recording their sales going into the courthouse, and this one thing that I've noticed, that yes, they may record themselves going into the courthouse, but they never have any follow-up video. They never have any follow-up video. Y'all notice that there's never any follow-up video. Oh, let me pull these up, y'all. Look, I'm about to show y'all everything. It's not, and the only reason why I'm showing this to y'all, so y'all can see. Only reason I'm showing to y'all, so y'all can see that the shit that they argue, the things that they argue, is 100% in line with the same things that the courts and the judges already says. So when I say the things that I say, I'm speaking it from a legal court case standpoint. But when I bring it to their attention, when I bring it to their attention, you know what they tell me? I get blocked, banned, or you don't know what you're talking about. That ain't true. Yes, it is. I did it the other day. Lying. They be lying like shit, y'all. They'll lie about it.
Let's talk about securitization. That's when your mortgage gets bundled with a whole bunch of other mortgages and it's sold to investors, kind of like stock. Okay, so when you thought you bought a loan, got a loan from Wells Fargo. Well, surprise, you didn't. It was sold into a trust on Wall Street. So the problem is they never told you that, and they didn't transfer everything like they were supposed to.
So it just sold to a trust on Wall Street. So vague. You know what that means? I really don't know any details about that. So trust on Wall Street. That's just like saying gap principles or ledger. They don't really get deep into the accounting because they don't know. So they never told you that. Number one, they don't have to tell you because that has nothing to do with your underlying obligation. Number one, it has nothing to do with the contract you signed. Number one. And number two, no understanding.
So they probably don't have any right to foreclose on you. If you want to verify it, you can go to the Securities Exchange Commission website and look in Edgar for your address and see what the pooling agreement was.
A practice that they stopped like 15 years ago. You cannot go on Edgar and find the contract because there was people in her comments saying, hey, I went on Edgar, put my property in, I couldn't find it. Do you think she responded? Nope. Look, everything she's saying. Right? Everything she's saying, right? It was not everything she was saying? Okay. Okay. Uh-huh. Regardless of this point, if there were a flaw in the assignment, Livonia does not have standing to raise that flaw to challenge Farmington's chain of title. As recognized by the district court, there is ample authority to support the proposition that a litigant who is not a party to an assignment lacks standing to challenge the assignment.
You're rocking with the best.
Universal on all courts. You come up that chain of sign or securitization chain of sign, it's over with. Unless, you know, of course, ain't talk about us because we know how to do it. But you get what I'm saying? Everybody else. This don't apply to me, but I'm just saying. It's only one way you can argue it. There's no, well, you got your way and I got my way. Like the guru told me, no, there's only one way to argue this. Only one way. There's no other way. Told you. Look. An obligor may assert as a defense any matter which renders the assignment absolutely invalid, ineffective, or void. And that is what we argue. That can't even bring this shit in the first place. That's what we argue.
Bring that one back from the top.
No trip. An obligor may assert a defense any manner which renders the assignment absolutely invalid or ineffective, or void. That's how we argue. These defenses include non-assignability of the instruments, assignee's lack of title, and a prior revocation of the assignment, none of which are available in the current matter because they don't understand mortgage.
You're rocking with the best.
Obligors have a standing to raise these claims because they cannot otherwise protect themselves from having to pay the same debt twice. In this case, Livonia is not at risk of paying the debt twice because Farmington has established that it holds the original note. Paying the same debt twice. The judge is trying to tell you something. That's one of our core arguments. Risk of paying the same debt twice, but not because of lack of chain of title. See, a lack of chain of title versus motherfucker, they ain't got the shit at all. They don't even own the shit. They don't got it all. Your Honor, that's bullshit right there. Actually, they're stuck with that. Is that? That's what y'all want to file? So when I get a foreclosure, I really be trolling these mortgage companies and be like, is that what y'all really want to file? I mean, you can't go back and change it now, but I'm saying, is that all y'all had? That's all you got? Yo, I got about 8 issues on you right now. Y'all still want to do this? Okay. That's it? How much they paying you? You mean they paying you $300-$400 an hour and that's what you come up with? No, I literally be emailing them that. Like, yo, that's it? You could have done better than that. Look, I got about 8 defenses to your one. Every one defense you got, I got 8 counters to it. That's it? I mean, that's all you want to come with? You're not making this hard. And I ain't even go to law school. No, I literally be sending that in the emails, trolling them. Like, that's it? Huh? Ah, come on. Go take that. Go withdraw that. Come back. Oh, by the way, you can't even change it because I already know how you really operate.
You're rocking with the best. You're rocking with the best.
Thank God for the Supreme Elite team. All praises to God for the Supreme Elite team. All praises for the Supreme Elite team. God, you have done a great thing by instituting the Supreme Elite team. I'm just a voice for you. That's all. I'm just speaking for you. Thy will be done. In this case, Lavanya is not because Farmer has established that it holds the original note. Farmington has produced ample documents that was in the possession of the note and that had been assigned all rights therein prior to the initiation of foreclosure proceedings. District Court reviewed the copies and exhibits and the originals produced by Farmington was satisfied that they're authentic. Without a genuine claim that Farmington is not the rightful owner of the loan and that Lavanya might therefore be subject to a double liability on his debts, Lavanya cannot credibly claim to have standing to challenge the first assignment. Why is that the same thing that we can argue? The judge is telling y'all how we argue it. And guess how the judges tell you how we argue it? That's the proper claim to make. That's exactly how we argue. I mean, I ain't gonna get into details, but that's exactly the angle. And the judge is sitting there saying, this is your angle you could come in at. Wow. Wow. Oh my God. Yo. Do y'all not understand that? The judge is literally telling everybody that the way the Supreme Elite team argues mortgages is the same way that the court just said that you can do it. That's crazy. Michigan case law provides further support that the district court's conclusion that Lavanya lacks standing to challenge the assignment. The Michigan Supreme Court held maker of a promissory note cannot challenge his obligations under the note by asserting that an invalid assignment had occurred. That's the hallmark of their claims today online. That's the hallmark of their mortgage securitization claims. Wow. Good God. Oh,
we're about to take it back.
The untouchable empire, baby.
God damn it, man. That's crazy. They literally said the same thing that I argued. That's crazy. Lavanya has attempted to distinguish itself from the unsuccessful obligors described by emphasizing that a challenge of the first assignment is not meant to challenge the underlying obligation, but rather to challenge the record chain of title. That is, Lavanya contends that a defective assignment corrupts the record chain of title, that Lavonia's challenge is only for the Farmington standing to foreclose under the statute. Lavanya's brief cites several cases which obligors have raised chain of title challenges, often unsuccessfully. The court is confirming what I'm saying. They lose all the time on these. For the proposition that Lavanya has standing to assert this claim, Lavanya further argues that because statute requires the foreclosing party to hold record chain of title, a debtor must be able to challenge the record chain of title as a means of avoiding foreclosure. Lavanya is correct that a party subject to foreclosure has standing to challenge whether a lender holds record chain of title, but that determination is limited to an examination of the public records.
You're rocking with the best.
Well, that kills their whole securitization angle. That kills the whole securitization angle. In its opinion on Lavanya's motion to reconsider, the district court clarified this difference, pointed out Lavanya acknowledges that a record chain of title exists, but is unsatisfied with the record chain of title. Because Lavanya finds no claim in the public record, it is seeking to go beyond the statutory requirements to inspect each and every aspect of every contract or agreement in the history of the loan. And the courts would never allow you to do it.
You're rocking with the best.
Because the courts understand there's a broader system than just your individual debt. They can't open the floodgates. There's a broader system than your little eeny weeny ting puny weeny debt. There's 336 million people and over 280 got financing. You want to shut the fucking system down so nobody can get financed unless you pay out of pocket? Without financing, we have no system. You're not going to shut it down for your little individualistic, peeny, inty, winty, meeny, weeny, teeny, weeny, my argument, I want to pay the debt, let me just expose the system just so I can get my little crumbs. They think so small-minded. They never look at it like, this shit bigger than you and me. And that is what separates the Supreme Elite team from everybody. We understand this is bigger than us. It's a whole broader system out there. It's bigger than our singular. I never approach someone's cases like they're singular. All right, just their case only. No, it's just their case. I'm just looking at their case. Nothing else. I don't see the writings on the wall. I'm just focused on your argument. Oh, I don't see any roadblocks. I'm just focused on you. I don't see where I messed up at. I'm just focusing on the facts, and I got to get the argument.
You're rocking with the best.
Nah, I swear to God, y'all. That's how these fucking gurus and people be out here, y'all. I swear to God, that's exactly how they be out here. They so focused on their singular case that they don't even understand how it looks in the broader public. Like they don't even know how to dress words up so it don't look like one big conspiracy trying to expose the system. I swear to God, this shit is ridiculous. As noted by the district court, even if Lavanya did have to contest the first assignment status and the assignment were in fact invalid, Lavanya was still be unlikely to succeed on the merits. Any claim by Lavanya that Farmington or the trust before it was not a valid assignee of the mortgage rings hollow, as Lavanya made mortgage payments directly to the trust for years without questioning the trust's right to receive. What did I say? They're going to say, well, you made payments for years. You ain't say nothing. What did I say? What do I always say? Hey, they're gonna be like, well, you made payments for all this time, you ain't say nothing. Now you want to bring it up now? I swear to God, I say that all the time. Well, you ain't bring it up now. You already made payments on it. You've been paying the same trust you talking about. You made payments and you ain't care. You made your payments. Why don't you raise it up at the beginning? And that's all what they're saying. That's all what they're saying. Well, why don't you raise it at the beginning? Why are you raising it up now that you're in foreclosure? Why did you raise this at the beginning? Why didn't you raise this at the beginning? Why are you raising it now? I told you, when you try to come in using that as a defense, and you made payments and made payments and made payments and made payments, and now that you in foreclosure, that you want to bring it up now, what did I say they're going to do? They're going to shut you down. So everybody that's in foreclosure being sued and you got to come into court and you try to come with defense, they're going to shut you down because hell nah. You ain't about to try to interrupt this system because you're one little singular teeny weeny beeny little debt when we got 280 million people. That's all they're saying, the same thing I'm saying. Because here's this. Phone calls were placed over the course of the next year regarding the down payment, which CAC admitted was down payment. Multiple letters and phone calls ensued, but the defendant remained silent. Nevertheless, plaintiff continued to make timely payments on the installment contract at a rate of blank. On July 1st, 2025, plaintiff made a final partial payment, and as of that date, plaintiff has made a total of blank. On August 18, 2025, plaintiff submitted an email attached with the first 29 pages of the operative complaint filed in this action. A copy of blank, and virtually every document filed in this action. As a result, on August 20th, defendant took plaintiff off auto pay and placed the remaining balance in non-applicable status. Further information regarding the payment history has been displayed. Payment information unavailable. Nevertheless, plaintiff continued to make payments until I decided to stop July 1st because I'm filing a lawsuit. So, Your Honor, listen, here's a paper trail of 16 months, paper trail, the conversations back and forth. I tried to get this matter resolved. And of course, again, this matter resolved. I already knew blinkety blink, right? But still, I still showed good faith and still made all my made my payments on time. Even though I know in doing something, and so I knew I was paying, but I still paid. Versus making your payments. Everything good. I ain't got no problem. Yeah, hey, we gotta make a mortgage payment. All right, bet. Shit, money getting tight. Damn, we can't make our mortgage payments. Oh, fuck, we getting sued. Hey, Your Honor, the chain of title was not good. I'm challenging the chain of title. But hold on, you made about 5 years of payments. Why didn't you say anything then? Because I ain't care. Well, why do you care now? Because I'm trying to keep my house and not pay for it. That is the reality.
You're rocking with the best. You're rocking with the best.
I told you, y'all think y'all cannot pay in the beginning, not pay when shit gets tight, and then court and try to raise these claims. The judge is going to be like, well, why didn't you raise these claims while you were current? And this is the part that 99% of these spaces cannot answer, because they know if they answer truthfully, they'll know I'll be exposing their disingenuous, trying to get something for nothing as natures. Why didn't you bring these claims up early while you was current? Why all these claims? The courts are not allowing it. You want to know why? because the courts are not just going to say it, but what they really mean is you're just trying to do this to get out of a debt, and they're not going to allow it. Lavanya alleges that the district court relied on a clearly erroneous finding of fact and denying the injunction. Lavanya places great emphasis on the fact that the original district court identified SACS as a party to the PSA, when the actual party was in fact SAC2, a separate entity. Lavanya submits that this error by the district court warrants reversal of his denial of Lavanya's request for a preliminary injunction because there is no evidence that exists that demonstrates the actual chain of title. But as already discussed, there is evidence of a record chain of title, and some of which Lavanya is so provided in the form of the title report. The district court properly relied on this evidence, considering Lavanya's likelihood of success on the merit. Lavanya did not assert, and there's no evidence in the district court that the court relied on anyway on the identity or SACS or SAC2. And the only reason why I blocked out some of the stuff I was reading in my motion, because they'll watch from the clouds, take my talking points, and then go run to their lives tomorrow and start teaching like they just been studying for months and years. Oh, they do it all the time. They watch what I say, then they run back to their group. No, I'm not lying. They would literally watch me from the clouds, watch what I'm saying. I wouldn't be surprised if Kenyatta have been watching this whole time from the clouds, because they watch me from Facebook now too. Let's just see. All right, let me get one more case. I got cases galore on people challenging the accounting. You know, courts don't deny the existence of ASE. They just deny it as a defense. You cannot use accounting as a defense. You cannot use securitization as a defense, like as your legal defense. Absolutely not. Let's go to one more case, and I'm going to get the hell up out of here because I got to. Why the hell did I do that? Let me go back to sharing my screen. Why did I do that? All right, let's go one here. And guess what, y'all? They was making these claims about 10, 15 years ago about the securitization in accounting. Why? And people used to get mad at me, and they still get mad at me when I be like, hey, yo, you know your claim is like 15 years outdated. Hey, yo, we got the next step, we gonna do this. I come in the chat, be like, you do realize that they tried that like in 2002 and it was denied in the courts. Here's the court case. You know, let me go and get the new culture up out of here. You fucking up my money. I'm gonna. You fucking up my money. You fucking up my money. You fucking up my money. They don't need to hear that. I don't want them to hear that. I just told them the pack is for sale for $75. I got 500 people in here. You know how much I can get? 250, at least 200 of them buy for $75. A lot of money for me. You ain't gonna fuck that up. I got bills to be paid. Yeah, y'all, we got the negotiable instrument packages for sale. Discharge your debts with negotiable instruments. But if you're gonna discharge your debts with, why don't you just use that to discharge your debts? Because what they do is they'll take your money and go pay their debts while they give you a worthless instrument so you can go pay your debts. Yo, y'all, people are so easily fooled. Yo, this shit is laughable at this stage. Yo, yeah, they be so desperate to get out of a debt that they end up spending more money with the person that's supposed to be helping them get out their debt than the actual goddamn debt costs. One key legal issue arising out of the collapse was whether how defaulting homeowners can challenge the validity of chain assignments involved in securitization of their loans. We granted review in this case to decide one aspect of that question, whether the borrower on a home loan secured by a deed of trust may base an action for wrongful foreclosure on allegations a purported assignment of the note and deed of trust to the foreclosure party bore defects, rendering the assignment void. The Court of Appeals held plaintiff Ivanova could not state a cause of action for wrongful foreclosure based on the allegedly void assignment because she lacked standing to assert defects in assignment to which she was not a party, aka challenging securitization.
You're rocking with the best. You're rocking with the best.
Told you. Told you. We conclude to the contrary that because in a non-judicial foreclosure on the original beneficiary, deed of trust, or assignee or agent may direct the trustee to sell the property, an allegation that the assignment was void and not merely voidable at the behest of the party of the assignment will support an action for wrongful foreclosure. Our rule in this case is a narrow one. We hold only that a borrower who has suffered a non-judicial foreclosure does not lack standing to sue for wrongful foreclosure based on the allegedly void assignment merely because he or she was in default on the loan and was not a party to the challenged assignment. Who has suffered a non-judicial foreclosure does not lack standing to sue for wrongful foreclosure based on alleged he or she was in default on the loan. Nor do we hold to suggest that plaintiff in this case has alleged facts showing the assignment is void, or that to the extent she has, will be able to prove those facts. And this goes to the procedural background. I'm not going to get into the case because it's going to get too long, but we're going to get to the argument. All right. This is non-judicial. I'm going to get to the fact. A beneficiary, trustee, or deed of trust who conducts an illegal, fraudulent, willful sale may be liable to the borrower. That's a fact. And these are all other cases where people try to, yeah, Glasky, that was a good one. Alleged certain. God damn, how long is this motherfucker? This may be too long, but this is Ivania. This is the case right here. It's long. So this is the case. But so y'all be able to see it. Y'all can look it up right there. That's the case right there. But before I go, I just want to ask one final question. I want to ask one final question. Can ASC be used as a defense to claim a debt has been satisfied? The standards is a framework for financial reporting. not a legal defense. Well, cases. So that is what they were looking for. They was looking for no. Can a borrower say as a defense? See if they got some off the top here. I got them in my files. It's just so funny. No, it's not what it is. It's not what I said. Not talking about accord and satisfaction. Oh my gosh. It's not what I'm talking about. So I'm going to post the links to the cases that deals with the accounting. I'm going to post the links to the cases that deal with the accounting. I'm going to post those so y'all can see securitization and accounting. It's right here. I'm going to post them in my, y'all watch out for my posts. And these are going to be the cases right here. In reference in Ray Walker. And this one was citing ASC violation, improper financial recording. And the court found those claims meritless and not actionable without legal injury or violation. So I got the cases. In reference, Walker, bankruptcy, Eastern District, Pennsylvania, 2012. It's the holiday season. We are getting to the meat and potatoes. We are going to run these claims up. We're going to run these claims up. We're going to continue to run these claims up. The Supreme Elite Team University enrollment is open now. ThomasLegacy603@gmail.com. Enrollment is open. Tuition fees better be paid on the wood because that makes everything good. And we will be having the professionals tune in to the classes as well. Enrollment is open now. Email for information. Enrollment sheet. Class starts February 2026.
I'm cooking up dog food. She play with the dick with the tosses. Smoking that leaf from Toronto. And watching that whisk like a car show. You look like you want to get shit off your chest. I thought so. I'm back in this game. Now you sit at the end of the bench. I thought so. Yeah, back in this motherfucker like I left something in this bitch. A whole gallon of the white. I'm getting drunker than a bitch. Big straps with the Mac 11s got me putting extendos in the clip. And lay your shit up on the curb. Like you didn't pay your rent. Got Papa John dope, but no pizza. The dope with his flipping straight O's and zippers. Right off the Peter Pan intake at 9 if you open the smell stick with you. My BBE label with guys on the table. Fuck your start of your Dracos. This map make you jump, no kiss cost in the stable. You get scott like potatoes. Shorty saying that I am the one. Who the fuck you think she Billie Jean? She want a nigga, put her on the team. After spitting out my kiss, a Listerine. The flow is bucking like it's Greek the Freak. But I keep it 44 like Pistol P. My really shitting on your biggest dreams. About to floor with you niggas, Mr. Clean. I'm cooking up dog food. She play with the dick with the tossers. I'm smoking that leaf from Toronto. They watching that whisk like a car show. You look like you want to get shit off your chest. I thought so. I'm back in this game. Now you sit at the end of the bench. I'm in the projects like I'm packed with a cake. They ask about it, they say missing no plate. I know the smells when they pull out them trays. It's nothing edible that sits in the place. Right out of prison, I ain't snitching nobody. And you ain't jumping lessons up on the base. I need some wife so I can splash in the lake. And I need a rat so I can eat, I'm a snake. My bitch for Louisiana and she Creole with stick in hand. Hop and all like she clear. We ain't missing, ain't no shots at the feet though. The out of time got them thinking it's zero. Sticks be as long as a cord extender. You get blown like a cartridge Nintendo. Fuck nigga, act you out like you know that. That's because you be playing the middle. I got an issue with the streets, it's breeding snitches. That's why I'm a family guy like Peter Griffin. Heard about Western Road, think I need a Smith. Issue time with his close, I think he a blister. Matters with the clips, I'm pushing T in my sack. The smoke, and you catch your T at your nap. Alphabet sticks, let the T in the map. Bitch, I'm hotter than few, that's gonna leak out the jet. I'm cooking up dog food. She play with the dick with the tonsils. I'm smoking that leaf from Toronto. They watching our waist like a car show. You look like you wanna get shit off your chest. I thought so. I'm back in this game, now you sit at the end of the bench. I thought so.
We are taking it to the next level. All right, y'all. Y'all already know what it is. New coach of Empire, Supreme Elite Team. Supreme Elite Team University, y'all. You want professional documents? Fuck the documents. Do you want just professional understanding? You have to understand the system before you can maneuver through it. And it's not the big stuff that people miss every day. This is the difference between understanding and not. This is the separation. Right there. That's how big. The little things like that. Lawsuits, courts. I don't care if it's administrative claim. I don't care if it's administrative document. You have to prove that you could be successful in court. If you don't have court enforcement in your documents, they're not going to take you serious. They are not going to take you serious if you don't have court enforcements in your documents. They're not going to take you serious. They're going to steamroll over top of you. Hey, this is wrong. We're requesting this. If you don't do this, we'll be able to prove this in court. And if you don't respond within 30 days, it still doesn't matter because we're taking you to court. And if you remain silent, then if you try to go to court and argue a different position, we're going to hit you with judicial estoppel. Number 3, we already got all the evidence against you. So either you're going to produce this, we know you have it, we don't need you to give it to us, but if you don't give it to us, we're going to request it in discovery. So we're going to scalp you at discovery, and then we can file other things if you had discovery. So do you want to settle or you want to go to court? You chose. I don't care. It don't make no difference to me. Either you settle or we go to court. You don't want to settle? We go to court. And we'll let the chips play out in court. Yeah, you got your little money right now. Yeah. But you know, I'm just building up equity. See, most people think about paying a bill because they really don't know how to get out of it. But the Supreme Elite Team, we just building up equity. So all the money that you paid into it, you just building up equity. Now you got real claims of equity. Because we don't argue the contract. Nah, we argue something else, man. We don't argue the contract. We argue something else. Motion for injunction, temporary injunction.
Nigga can't even sleep. Her pussy all in my face. Nigga can't even eat. Got me clenching my jaws. Nigga can't even speak. House surrounded by hitters. Nigga can't even creep. That fuck shit for the burn. Don't give a fuck about your feelings. Liddy gonna treat the bitches like a turn. We pulling up, just get a word. A lot of you niggas floating straight garbage. I'ma send you niggas by the curb. Fuck a charge in my lawyer and he's showing up and looking like a nerd. hard speaking, no English. Them niggas got the phone whips. Fuck boys and real niggas would never ever coexist. Just came home and got no paperwork, never let a man on it lit. My bitch know I got good dick, never talk about it with her friends. We gon' do this shit like a man, walking down out the whips. You ask a lady for a favor, that ain't my language, yeah, you talking French. Just turn the page on the chapter, money pals what I'm after. So what the fuck is you saying, nigga? Shit don't even matter. Bitch know that I'm the man. Jumping in my DM, thinking nigga sweet, trying to work me with the scams. I was on the plane, shackled up with the lunch bag in my hand. Was on 23 and when he came by my cell, hit me with them Zans. Oh man, if I'm not with my wife, then I'm with a bad bitch. All the mokies in there try doing backflips, diamonds icy, you can skate on them hat tricks. Dirty hoes, pussy smell like a catfish. Wish you was on my team like my last bitch. Fresh feelings down the toilet, my last shit. I ain't stopping till they dip in the casket. Still dripping, but it's slow like molasses. Pop me a Molly, nigga can't even sleep. A pussy all in my face, nigga can't even eat. Got me clenching my jaws, nigga can't even speak. House surrounded by hitters, nigga can't even creep. That fuck shit for the birds. Don't give a fuck about your feelings. Liddy gonna treat the bitches like a turd. We pulling up, just get a word. A lot you niggas flowing straight garbage. I'ma sit you niggas by the curb. And fuck a charge to my lawyer and he showing up and looking like a nerd.
Too much liquor, nigga can't even try. Say on the deuce, I done dropped about 5. If I done step in the beat with my 5, you gon' run up in your head when he fry.
Credit acceptance internal model. How they mark up the prices. Down payment amount should be at least 25 to 30% of the vehicle's cost. Be sure to use dollars amounts like $2,999 rather than $3,000. Arrange the vehicles in the lot according to price. I got their whole model. I got credit acceptance whole. Buy vehicles within $1,000 of Black Book wholesale. Hey, basically saying buy the vehicles low. Look, I got the whole internal model. So all the dealerships across the world that deal that's in the credit acceptance network, nose running. Can't blow my nose on camera. I hope I'm not getting sick, y'all, because that's going to be a travesty. I got their whole model. I got their whole model. I got how it shows how much your vehicle really costs and how much they jack the price up on you. How much they really expect to get and how much they tell them to charge you. So I'll be like, yo, Your Honor. Hey, Your Honor. Psst. They said I owe $41,115, right? That's what they say. But this is how much they internally, this is how much they said I really owe. So, Your Honor, I already satisfied that balance with my monthly payments.
You're rocking with the best. You're rocking with the best.
I just popped me a Molly. Nigga can't even sleep. Her pussy all in my face. Nigga can't even eat. Got me clenching my jaws. Nigga can't even speak. House surrounded by hitters. speaking no English. Them niggas got the phone whips. Fuck boys and real niggas would never ever coexist. Just came home and got no paperwork, never let a man on it lit. My bitch know I got good dick, never talk about it with her friends. We gon' do this shit like a man, walking down out the whips. You ask a lady for a favor, that ain't my language, yeah, you talking French. Just turn the page on the chapter, money pals with them after. So what the fuck is you saying, nigga? This shit don't even matter. Bitch know that I'm the man, jumping in my DM thinking nigga sweet, trying to work me with the scams. I was on the plane shackled up with the lunch bag in my hand. Was on 23 and when he came by myself, hit me with them Zans. Oh man, if I'm not with my wife, then I'm with a bad bitch. All the monkeys in there try doing backflips. Diamonds icy, you can skate all them hat tricks. Dirty hoes, pussy smell like a catfish. Wish you was on my team like my last bitch. Flush feelings down the toilet, my last shit. I ain't stopping till they dip in the casket. Still dripping, but it's slow like molasses. Pop me a Molly, nigga can't even sleep. A pussy all in my face, nigga can't even eat. Got me clenching my jaws, nigga can't even speak. House surrounded by hitters, nigga can't even creep.
Say all that.
Don't give a fuck about your feelings, Liddy. Gonna treat the bitches like a turd.
What they say.
Just get a word. Allow you niggas flowing straight garbage. I'ma sit you niggas by the curb.
But they not sent them pics.
Like a nerd.
Only owe 9,000 for real. 41,000. I literally showed them only owe 9. And it's not because what I believe. That's what they already said, what I really owe. But that's the trick. That's the contract trick. That's the contract trick. So when they repossess your vehicle, you probably already made the payments to pay it off. They just, write it off. Snatch your vehicle, sell it for way less, and then be like, hey, Your Honor, he owed 41,000. We was only able to sell the vehicle for about 10. We need a 30,000 judgment. That's the scheme. But what I did, I was like, you say I owe what again? But these show that I only owe this, and my payments I made on the contract satisfy this amount. And this your words? These are y'all words? Is this what y'all, this your words, right? So what's there to talk about? So we both know the contract is bullshit now. Let's get that out the way. No, this is me talking to him in the email, like on the phone, like. So we know the contract is bullshit. We know, you and I both know I don't owe this amount for real. Never did, but kicks and giggles. Let's just say I owe this amount, right? But then I sent you your internal models, and it only shows that I owe this amount. Your internal documents, and it showed that I owe this amount. But when I tally up all the payments I made on the account, it satisfies the amounts that you really behind the scenes say I owe. My problem here, well, I'm gonna file a lawsuit against you. Yeah, you ain't gotta worry about that. I'm gonna prove it. Professional courtesy, I'm gonna send you 29 pages of the motion that are going to be filed. You get the first 30 pages. You'll get the rest when I serve you. Once the judge proves that I stated a sufficient claim that allows me to serve you, then you'll get the rest. And since we're transparent, I'm going to send you everything I'm going to request in discovery. As a matter of fact, I'm going to send you everything now in the email that I know you have, because I have it. And then I'm legally going to request it from you in discovery at that stage. So you already know I have your internal documents. We've already satisfied that part. We already got your internal. This is what the dealerships use. So I already have this. I know it's your proprietary caps model. I know. I have it. It's okay. I have it. Okay. So, but since it's not a legal setting, I'm just going to let you know I have it. So, I'm going to officially request it in discovery, and I'm going to word it so you, and then I'm going to send you a copy of it again, just let you know. So now you can give me the information so I can go back to the judge and say, hey, Your Honor, motion for summary judgment. Now, if you don't do it, I'm going to do it anyway, but I just give more satisfaction of you giving me what I need to scalp you, knowing we both know you have it, and I know you don't want to give it to me, but you already know I got it, so you can't really play no games because the gig is up. So that's why you see shit like this. That's why you see shit like that. The gig is up. Like, it's up. It's over. The smoke screen. I got you. It's more just like, damn, he got us. Damn. How the hell did he get that? Was there a leak? How the fuck did he get our internal models? The borrower's never supposed to have that. That exposed the whole system. How did he get that? With not everybody else credit except
You're rocking with the best.
Yeah.
Not everybody else.
Yeah, I know what it is, nigga. You don't know what you know about now. Like I said, nigga, I don't ain't here to make no motherfucking friends. Gonna be buddy rappers with niggas. Man, this bitch would have money, nigga. That motherfucking money. That's the only thing that moves. I don't give a fuck about nothing but that bad, nigga. And racks, nigga. And stacks, nigga. Any means necessary, nigga. By any means, nigga. That man about to drop me half a thing all right now, nigga. Nigga, I can't wait, nigga. Let's get it. He just wanna stack in the lead, nigga. Dead in the.
So when they establishes brand new loans, when you're sitting down at the dealership, this the screen they looking at. This the screen they looking at. Yo, when I went to the dealership and showed them that shit, they was like, I was like, I know, right? This shit, yeah, hey, I'm like that, ain't it? To have that. Like, yo, how did you get that? Hey, I'm like that, ain't it? I know. I'm like
dead in the dish, okay, I let you know. Them kids got a lot of them cutters, got legs in their end. Oh no, don't play with the folks. He whipping that pots and that nigga in love with them trays. Woo, like fuck with the lopes. Every dollar that I'm touching, leave blood on my hands. Yup, and there's blood on the dope. Yeah, we ballin' these stacks that I jumped out the gym. Hey, rubber band stopped in the bands. I got stacks in my hands, it's in K on the strips. Hey, bitch got her face in my lap. Hey, I'm blowing it straight out the zip. Hey, they ain't no shaking these packs. Hey, and never a day able to say. Yeah, dropping the brick in the shit. They got that lick in my wrist. Hey, we take the scale out the fish. Yeah, bitch, you could tell that we rich. Yeah, I got these niggas on skates. Look at these niggas, they hate. Yeah, they mad their bitches are rolling. And they got bricks. Yeah, and we gonna come out straight with a drum and they can't make you run like you Drake. Yeah, diamonds are cold as a freezer, but big as the ice as I come on the tray. Yeah, hang from the neck, got it dripping. Yeah, follow the truck to the kitchen. Yeah, they pull up rocks at the pot and they chopping the blocks, but they dope, but they sifting. Yeah, they got a blender, they shifting. I'm fucking my bitch and her sister. Yeah, well, half of my knowledge and they splinter. Yeah, they eating this dick up for dinner. Yeah, throwing them stacks on them strippers. Yeah, can only do that if you winning. Yeah, and if it's stacks that you get in, then you gotta lift the bitch stacks to the ceiling. Let's get it. He just wanna stack in the lead, nigga, dead in the dish. Okay, I let you know. Them kids got a lot of them cutters, got legs in their end. Oh no, don't play with the folks. He whipping that pots and that nigga in love with them trays. Woo, like fuck with the lopes. Every dollar that I'm touching, leave blood on my hands. Yup, and there's blood on the dope. Yeah, we ballin' these stacks that I jumped out the gym. Hey, rubber band stopped in the bands. I got stacks in my hands, it's in K on the strips. Hey, bitch got her face in my lap. Hey, I'm blowing it straight out the zip. Hey, they ain't no shaking these packs. Hey, and never a day able to say. Hey, yeah, step out the whip and they look at my way, I just look at him. Put some bands on his book for my nigga that just threw the book at him. I'm trying to get me a quart on a plate, the devils just look at it. Hey, bro, niggas, but get out her face, your bitch trying to look at me. Trapping the best on the jeweler, the chopper too long, leave the ruler. I'm checking in time on a mule, and they should be landing in Cuba. 10 racks on the pack, cause we move with the put the 10 racks on your head and you shoot it. Then chopper like cycles is lighter than Michael and Booba Jackson with the Ruger. They come with that mask on like Jason, they snatching your bricks and they break down ace out the keys. They taking it all, won't leave you with nothing, not even an eighth for you to keep. Who said we walking, just look at the fleet. Ain't doing no talk or reach under the seat. Nigga, you stay like a bum in the heat. We can like Chester's 100 a week. Yup. He just wanna stack in the lead, nigga, dead in the dish. Okay, I let you know. Them kids got a lot of them cutters, got legs in their end. Oh no, don't play with the folks. He whipping that pots and that nigga in love with them trays. Woo, like fuck with the lopes. Every dollar that I'm touching, leave blood on my hands. Yep, and there's blood on the dope. Yeah, we ballin' these sacks that I jumped at the gym. Hey, rubber band stop.
Mr. 100 Rand.
So if money talking, my talking round the clock. What you need, you cop it. Them pills, them pounds, them rocks. A couple niggas ballin', cause they got a block. A royal flush will spot them. Right around the top, so I'ma make it bounce back. So all you get is straight piss. You fucking niggas' pockets, now they need a rake kit. Money's my motivation, that's why they hate this. Mommy talking round the clock, nigga no breaks, bitch. We carry big weight, we will big pun the streets. Been about mine since I was in my dungarees. We blow a big tree the size of a jungle leaf. He think he big meat supplying with 100 piece. I'ma make it bounce back so all you get is straight pip. Triple B, no in between, so all the bitches can't miss. Have your daddy stuck right down that chimney like Saint Nick. To take your 2 cents and stick him in your anus. It's royal flush, nigga. I see your pantyhose. You bragging about one bra, bitch, nigga, I any hoes. I do not mingle, rotate them like hot singles. Just the sound of my money make they twat tingle. So if money talking, my talking round the clock. What you need, you cop it. The pills, them pounds, them rocks. A couple niggas ballin', cause they got a block. A royal flush, they spot them. Right around the top, so I'ma make it bounce back. So all you get is straight hit. She fucking niggas' pockets, now they need a rake kit. Money's my motivation, that's why they hate this. Mommy talking round the clock, nigga no breaks, okay? I'm the lotto pick, I keep an honest click. And if we were a thing, that wouldn't be stopping it. We smell a bitch as if he stuck up in some doggy shit. Shorty this my money, that gives me doggy licks. It's absurd how the chain is chipped up off the bird. Oh, half the rims, half the panties taken off his girl. Fuck the ground, oh my niggas post smell them birds. They say talk is cheap, so I'ma wholesale my words. I'ma make it bounce back. Niggas getting straight pit, choking to his face blue. Bust the nigga bang crip. Fuck around, all my niggas on that same shit. Yeah, ain't no problem to get banged quick. So if money talking, my talking round the clock. What you need, you cop it. The pills, them pounds, them rocks. A couple niggas ballin', cause they got a block. A word of flush, you spot them. Right around the top, so I'ma make it bounce back. So all you get is straight hit. You fucking niggas' pockets, now they need a rake kit. Money's my motivation, that's why they hate this. Mommy talking round the clock. Blazer out of spaceship.
Hey, yo, Carter, you going crazy. Hey, run that shit up, Chase.
Put this dick in the thotty. This is Jalo and gimme. Down on her knees. My pockets on sugar. My bitch cooking like silly. Run it up. My weed color purple. Got me stuck to the ceiling. Straight to the moon. I order up dope. Yeah. She don't cut, she just send it. Watch out for whip. Finesse the niggas, watch it shake. How many? 100 pies, watch it bake. What's that? Package dropping off the route. Okay. Candy spraying like it's mace. I put my money on the plate. Right here. Then she put my kids up on her face. She brought the nigga straight to sleep. Ate the dick up like a cake. Spit raw, got a dope mouth. She sucked me off in the dope house. Fuck all night with a dope dick. Up all night, take a dope trips. My niggas blitz you for that dope sack. For the dope bag, get your toe tagged. Born rappers going broke fast. I'm lying on them like a dope nap. I'm picking up weight. I got my check up on these niggas. Don't sweat on these niggas. Free wreck on these niggas. No respect of y'all and no self on these niggas. I don't need a gun. I'm the boss of the shooter. I got the balls of a shooter. My head to get popped. I call up the next one. He torture reflexive. You left by the Luger. I whip with the bread like a slave. She stacks up a triple like Rays. Blow on the perk. Got me lost in the head. Still take a pounce on these niggas like Abe. I turn your hood to my trap spot. Got your junkies cheering like a mascot. Catch your auntie with a glass dick. Watch her dance around the crack pot. Put his dick in the thotty. This is Jalo and gimme. My pockets on sugar. My bitch cooking like silly. My weed color purple. Got me stuck to the ceiling. I order up dope. She don't cut, she just send it. Finesse the niggas, watch it shake. 100 pies, watch it bake. Package dropping off the route. Cannon spraying like it's mace. I put my money on the plate. Then she put my kids up on the face. She brought the niggas straight to sleep. She ate the dick up like a cake. Run it up, run it up, run it up, run it up, run it up. Watch out for the man in the backs. Hey, we whip out the bands to be back. Whip it. We whip out the grams of the plastic racks. Jackie Jordan with the try me. 8 for coldest, bacon sodas, get your action. Yeah, we get it stretching like elastic. Here, chopper like I'm Jackie. Hey, back to the money, switch up the flow. Don't conversate if you don't speak the language. My niggas deeper than the congregation. We still a flipping bird like middle fingers. I traded the streets for these millions. Still I place a call to put your life in danger. Still got hitters with the choppers that'll eat you up like the candy. Now or later, could get me a kilo to flip. Cause I get it popping like kilos to six. Think he showing up out with Leroy and shit to go Craig on his ass. Trying to deep on shit. Liddy, nigga. LeBron James to these racks, boy. And I'm pinning shit off the back, boy. Wow. 100 right around your ones. Hell no, it ain't a stack, boy. Put this dick in the thotty. This shit jollo and gimme. Down on her knees. My pockets on sugar. Whipping the whip. My bitch cooking like silly. Run it up, run it up. My weed color purple. Hey, hey. Got me stuck to the ceiling. Straight to the moon. I order up dope. Yeah, yeah. She don't cut, she just send it. Watch how we whip. Finesse the niggas, watch it shake. How many? 100 pies, watch it bake. What's next? A package dropping off the route. Okay. Cannon spraying like it's mace. I put my money on the plate. Right here. Then she put my kids up on the face. Oh Lord. She brought the niggas straight to sleep. Gone. She ate the dick up like a cake. Hey. Block boys, niggas, geeks, money. Yo, we fucks bitches, and they sell drugs from chicks to pigeons. Still keep that banger, this is not no prison living. A two-time felon, this is the biggest vision. I blow smoke, but never did I need prescriptions. I just needed pipness in a scheme to get rich. My man's whipping while I'm watching from that pirate vision. And he whipped it all from that heart to soul. The niggas on the strip is looking like it's Mardi Gras. Who got the dope? Oh, we don't know because they copped it all. They call him if they ever need some trap help. Cause how we chop the bricks, I think he needs a black belt. The small time hustle, I was never into it. Fuck what they say, but me and Benjamin are intimate. They all think we crazy. I just call them haters. Ain't got no feeling, Lotto. How you fall in love with Betty? Jump about that window, better ask about me. Big money, heavyweight. If you ask about me, I keep it real. I don't never fake. Just ask about me. My name will bust through every state. If you ask about me, about me, about me. If you ask about me, about me, about me. If you ask about me, about me, about me. If you ask about me, about me, about me. If you ask about me,
You're rocking with the best. You're rocking with the best. You're rocking with the best. We're about to take it back.
Yeah. It's Liddy. Okay, I'm almost wasted, and my drip is on the spaceship. One more sip, yes, I can taste it. Come to my exact location. I'm so tired of my probation, doing time for revocations. I just toasted this occasion to give myself standing ovations. What I'm drinking, that brown, that white, with the buzzwords, that ass is attractive like a magnet. I never dodge her. I drink my problems away, and that alcohol is my sponsor. And I will indulge you to the point of death. That's only if my heart hurts, cause relationships never last. And being faithful is a thing of the past. Everybody's only after one thing. Both sexes can relate to that. Can replace the fat when they hit it from the back. Get your face in my pillow when I palm in your ass. Yeah, I graduated from the bottom of my class. Now I'm sitting at the top. You see the bottom of my glass. We can keep talking. I know that's where we're headed. It's my train of thought. It's so terrible to be embedded. Did I mean it? Only if I said it. Remember her face. I normally forget it. Get it, hit it, quit it. Send it on the way. Package, shipment. It's hard to react if your heart ain't attached. Acting like it ain't love. You be calling her back. Wake up in the morning next to an empty bottle. Wonder what she said that made you really want to follow. Words come out. I know I'm drunk. Somebody send me another one. Oh, shit. It's
Okay.
Get it, bag it, get it, bag it, get it, bag it, get it, bag it. Red in my car like a bracket. Blue diamonds on wrist like a cracker. The locator dropped and attacking. Taking everything out to be stacking. Get it, bag it, get it, bag it, get it, bag it, get it, bag it. Red in my car like a bracket. Blue diamonds on wrist like a cracker. A locator dropped and attacking. Taking everything out to be stacking. See showing straps in your pimp, you ain't gon' slide. Happy niggas got a fans looking for them, nah, they ain't gon' lie. Bitch, nigga, I'm spinning. Put your ass in that blender. Got a cartwheel in this tech. You know the dog gon' flip it. Stuck to the ceiling. It's robbing the bitches, the rapper to get me. Blowing the backs with the Simmons. They're all over the back of the Simmons. What I get for the single look like it's double guarantee. I'm a triple that. Bands out the ass, they gon' triple stack. I got different pass like the nickel back. My niggas gon' try to be stacking. Get a drop that we ask me attack it. You just give me a week and flip over like the piss inside of a mattress. Got the raw in shipments. Cold as a bitch, got us all in the building. Jumping all on the stairwell. Only move for the women and children. It's the feeling, the wake of the money. Counting that bag while you only get bloody. Your bitch in the bed and she sleep. You ain't tripping at 6 in the morning. The phone is still ringing. Hello? The money is calling. 20 minutes. The money is calling. Just made a band while I'm yawning. Okay. Bro, niggas are speaking the bonics. Get it, bag it, get it, bag it, get it, bag it, get it, bag it. Red in my car like a bracket. Blue diamonds on wrist like a cracker. The locator dropped and attacking. Taking everything out to be stacking. Get it, bag it, get it, bag it, get it, bag it, get it, Bagging. Red in my cut like a bracket. Blue diamonds on wrist like I'm cracking. I located, dropped and attack it. Taking everything out, then we stacking. Counterfeits out the cash vaults. Working niggas with the band salt. I know he think he get the whole thing. We just triple right the head block. Wings coming in a glass jar. The trappers moving like a NASCAR. Blessings coming from the trap guards. Bricks chopping like a hacksaw. Run to the money and push it. You get to see us cooking. Master B, I got the hookup. We laying no cuts like a hooker. We waiting your ass like a taxi. In and out of your crate like a trap me. The cannon that come with attachments. Wait, that's how you nigga like Maxis. We're blissing nigga with the full package. Dogs bigger than the bull massive. We flexing, that's a nigga straight at him. He ain't stacking, got a straight jacket. Go rollies on wrist, no ticks. You got 50 niggas with no licks. 30 shit sells like a kilo. Line you up with the whole brick. Get it, bag it. Get it, bag it. Get it, bag it. Get it, bag it. Red in my car like a bracket. Blue diamonds on wrist like I'm cracking. The located, dropped and attacking. Taking everything out to be stacking. Roll it, gas, water, splash, go get 200, that's on it. Dash, we stunning. Okay. DV niggas ain't running. Checking it with who you frontin'. Send 100 things with the runners. Hey, nigga. Thomas. Bad boy, no Diddy, I been that nigga. Rolls Royce culling and bending that nigga. Spent 2 times with the drillers. I'm up one standing on business, my nigga. Bitch got hair like a Barbie. Okay. Get in front of just Molly. Going up all night off Molly. She eat the whole team up, gobble. All gas, no brakes, just throttle. I move like an earthquake. Your bitch got a bird brain. And I'm shitting on you niggas. You at the bottom of the bird cage. I eat a cake like a birthday. She let me drink when it's Thursday. Okay. I met her on a Monday. Was on the pussy on the third day. Gash, water, splash, go get 200, that's on it. Dash, we stunning. Okay. DV niggas ain't running. Check it out with who you frontin'. Send 100 things with the runners. I know 5-star bloods, no stunning. I got DC niggas with the cutters. My niggas bang blue, we coming. Spin the whole block in the hatchback, nigga playing files on the streets, we flooding. 100 grand calls on the throwaway, nigga. Talking about commas, yeah. Black girls, bitch, be bad. You broke bitches getting no money. You broke niggas.
Bring that one back from the. You're rocking with the best.